Hello. Yes, I'd like to mention first lawsuits. I have taken the concern of the petitioners lawsuit, item number 40, 41, and 42. It's for contempt lawsuits. Here we have to file an affidavit. Two affidavits is ready lawsuit. One affidavit lawsuit, some inadvertent mistake has happened, so we couldn't file it. Let it come on Monday or Wednesday, any date lawsuit next week. They have given the consent lawsuit.
40, 41,
40,
42.
41, and 42 lawsuit.
Is this the same matter which
Yes,
was
yes, same.
listed yesterday?
No, those are in supplementary list lawsuit.
Okay. When do you want it?
I am for the. He is for the petitioner.
When do you want it?
Next week, any date lawsuit.
Why do you want time otherwise?
Monday or Tuesday,
No,
Wednesday.
why do you want time?
For the affidavit lawsuit, one affidavit, we have some mistake was happened lawsuit. We have to need some more information from the district. So that we could not incorporate. So we want to incorporate that and file it. By Friday, we'll file it lawsuit.
Okay, Mr. SMP Chisti Learned Counsel for the respondent submits that he is awaiting some further instructions for filing affidavit, and therefore he prays for a week's time to file the affidavit of the respondent. So as paid for is the matter again on
26, madam. 26.
Sorry.
26, yes.
26/11.
Oblige, your lordship.
Lordship, I am praying for listing of a contempt case, Lordship, next week, Lordship. This case
Motion.
was listed last on August, Lordship.
Motion.
Lordship,
If it's not a motion, don't mention. You approach the registry for the listing.
May I please Lordship, with the consent of the opposite counsel, I beg to mention item number 21 for adjournment. But my senior engaged counsel, due to some personal difficulty, could not attend the court today.
I'm for the petitioner, my lord. Fixed on second. The court has to argue the matter.
Who is not able to appear today?
I am for respondent number 3,
Who is the counsel?
Council.
Mr. K.U. Ahmad.
Is for which respondent? Is for which respondent?
Principal of the college.
Respondent number?
Three.
Three.
It's one number three, madam.
Okay, Mr. K.U. Ahmed, learned counsel for respondent number 3. He said he has some personal difficulty to appear before the court today. Upon a prayer made on his behalf and not objected to by the other side, matter stands adjourned.
2nd of December, my
To
lord.
be listed again on so and so.
Thank you.
212.
Grateful.
May I please your lordship, my lord? Lordship, in item number 19 and 20, lordship. Lordship, item number 20, lordship, day before yesterday, lordship, they have filed an affidavit in opposition, lordship. We need 2 weeks time to file our affidavit in reply, lordship, in this matter. I have already taken consent from that.
As paid for by the learned counsel for the petitioners. 2 weeks time is granted for filing reply affidavit to the affidavit in opposition filed in WPC number 6268 of 2024.
Lordship,
List again after 2 weeks.
lordship, deeply obliged, lordship.
May I beg, Lordship? My lord, one prayer made for listing of the case for admission, my lord.
You approach the registry for listing.
Obliged,
May I
obliged.
please Lordship, I am prayer for listing one WPC Lordship. The petitioner are going to be retired in the month of December.
Motion matter.
Admission Lordship.
You just heard what I told the other counsel. Yes, next.
May I please the lordship? Lordship, I beg to mention item 24, my lord. My lord, in this case, the opposite party has filed, respondent filed their affidavit. I would like to file reply to the affidavit.
How much time?
2 weeks time, my lord.
As paid for by the learned counsel for the petitioner, 2 weeks time is granted for filing reply affidavit to the affidavit in opposition filed by the respondents. List
Deeply obliged.
after 2 weeks.
may I please your lordship? Lordship, I am praying for listing of a fresh IA for tomorrow, Lordship. IA is
What is
regarding
DIA?
seeking some protection from this court. What has happened, the state respondent in the education department has floated an advertisement where the contractual teachers who are currently working, they've been allowed to apply under special recruitment drive. We are also a set of workers who are working for last 15-20 years, but those workers has not been named under a special recruitment drive. So we have filed an IA. Our petition is still pending. And the IA be taken up tomorrow, Your Lordship.
Secondary.
No,
What
it's
is
a-
the urgency?
urgency is that they have floated the advertisement and they're seeking the online application has been started.
Started means what is that date?
They have started from
Up to which date?
Lordship from 8/11/2025 to 30/11.
11. So we'll have it on Monday or Tuesday next.
Lordship, Monday then.
Monday? Tuesday.
Lordship, can it be Monday because my senior will not be there on Tuesday? Kindly some accommodation also on Monday.
Oh, you have it on Wednesday. Wednesday.
Lordship on Monday, Lordship.
Wednesday.
Lordship, my senior, I'm led by my senior, some,
You will let him also make accommodation accordingly. If you want.
because he'll be out of station from Tuesday, folks.
Huh?
He'll be out of station from Tuesday.
I'm saying Wednesday.
Yes, Lordship, he'll be
So
out.
you move it. If your senior is absent, you move it. You are aware about the case. Yes, next.
Obliged.
Your lordship, I beg to mention for listing a matter for motion for tomorrow, lordship.
What is the urgency?
Lordship, non-payment of salary, lordship.
That will take its own time.
Lordship, then Tuesday, lordship, motion matter, lordship.
Next Wednesday.
Next Wednesday, lordship. Oblige, your lordship.
May I please your lordship, I'm back to mention for listing your lordship for hearing.
Listing you approach the registry. Yes.
May I place your lordship? Lordship, I beg to mention item number 22. Lordship, may adjourn this matter for the day.
Why?
For some personal difficulties.
Who
of my-
who has personal difficulty? You are mentioning on behalf of the petitioner or the respondent?
Petitioner,
Who is the counsel?
Mr. R. Islam.
What about Mr. Hussain and Deka, Miss Deka, Miss? There are three counsels,
They are not come.
and your good name?
He is Mullah. My name is not mentioned in the cost list.
On a prayer made on behalf of the petitioner, this matter stands passed over for the day.
For withdrawal item 1 of the daily list.
Yeah, please, Your Honor. My lordship, with the consent of the, with the instruction of our guideline, I want to withdraw the matter, my lordship.
What is your name?
My name is Ann Barman. I am appearing on behalf of Mr. Senior Common Advocate B.D. Das.
Huh?
I am appearing on behalf of Senior Common Advocate,
Government no.
Senior Advocate, B.D. Das, my lord.
Please tell me your name again.
Ann Barman.
Miss N. Burman, learned counsel, appearing on behalf of Mr. B.D. Das, learned senior counsel for the petitioner. Submits that she has instructions to withdraw the writ petition. Of Mr. S.M.P. Chisti, learned standing counsel, secondary education has no objection. In view of above, the petition stands dismissed as withdrawn.
Item 2 for withdrawal.
Lordship, as per the instruction of the client, lordship,
What is your name?
DJ Boro, lordship.
DJ,
Yes, lordship.
Mr. DJ Boro, learned counsel for the petitioner, submits that he has instructions to withdraw the writ petition. Mr.
Yeah.
A.R. Pahibildar, learned standing counsel higher. Education has no objection to the prayer. In view of above, the petition stands dismissed as withdrawn.
56 of the supply list.
May I please, lordship? My lord, I may be allowed to withdraw this petition with a liberty to file a fresh. My
Why
lord.
liberty?
Liberty, my lord, they have got some documents, my lord, government document, my lord, they will annex one.
Hmm?
In the meantime, my lord, they have received some other relevant government policies, my lord, they will annex all those.
There are some developments.
Yes, my lord.
Yes, lordship, for elementary.
On the prayer on the prayer made by Mr. A.M. Barbuya,
AM Bolvia.
learned counsel for the petitioner, and not objected to by Mr. S.N.P. Chisti, standing counsel, elementary education. Writ petition stands dismissed as withdrawn. So however, liberty is granted to file afresh, if so advised.
All right.
For motion item 3.
You had one more, right?
May I please, your lordship.
If so advised.
My lord, order is at page
Aspect.
33. Order is at page 33. This is a contempt petition, man.
Page 33.
My lord. This is from gate 44 to gate 3, my lord.
Yes. Then after what happened?
Thereafter, my lord, petitioner filed representation, detailed representation, annexure 9, page 35. This is pending since 2020.
No, no. Your representation is dated 18/8/2025.
My lord. Thereafter, my lord,
Just
Annexure
2 months
10.
back,
my lord,
just 2 months back.
my lord, case is pending since 2020, my lord.
Maybe. But why the hurry of filing this contempt?
My lord,
There's no time frame also as such.
yes, my lord.
You should wait for some time, isn't it? You have submitted your representation only on 18 August.
18 August.
Now we are in November, early part of November.
My lord, whole case is pending since 2020. That is, my lord, I have stated in my representation, my lord.
So that we've seen.
Fourth 2020. And last order is 2011-2020. Page 35, my lord.
Your representation is before which authority?
Inspector of Schools.
Only.
My lord, he forwarded the whole document before the Director of Secondary Division.
Where? Where's the forwarding?
That is, my lord. Page 11 of Annexa 11, page 39. And page 37, my lord, Joint Director also called for all the documents regarding the petitioner. Page 37. Oh, my lord, at this time, notice may I go, my lord?
Inspector of Schools, then one is the director.
My lord.
At this stage, we may issue notice only on 2 and 3,
My,
not others.
my lord.
Heard Mr.
P. Chalukar.
P. Dalukar, learned counsel for the petitioner, who submits that the order of this court dated 6/8/2025, passed in WPC number 4377 of 2025, has not been complied with by the respondents. And therefore, the present contempt petition has been filed by the petitioner. Stop. In view of above, issue notice to respondent numbers 2 and 3 only at this stage, returnable by 4 weeks. Petitioner to take steps for service of notice upon the respondent numbers 2 and 3 by registered post with AD due within 3 days.
My lord.
Just again after 4 weeks.
Item 4.
My please, Your Lordship. So I was instructed to get some instructions with regard to the pendency of the appeals in the State Information Commission as per the last order, Lordship. I appear for the respondent number 6.
What is this appeal?
He has filed an appeal under section 19(3) of RTI Act as a second appeal, Lordship. And he wants that to be disposed of within certain
Appeal under RTI Act.
RTI Act, second appeal.
So what has happened? What is the instruction?
Instruction is that we are dealing with the appeals which were filed in 2024 and his appeals of 2025, which we have not yet considered for the hearing, though it is registered, but it is not, it has not been considered for hearing. However, if I'm under instruction to state that, Lordship, that we can consider it at the earliest stage if Lordship passes an order with regard to the appeals which is pending.
Why do you need an order from the court to
Lordship-
consider the appeal?
Not with regard to the order, Lordship. It is considered on a serial basis. So it is filed only in 2025. We are considering the appeals of 2024.
Where's the appeal? Show me.
Page
Which number?
89,
Huh?
page 89.
What is the information that you have sought for?
My lord,
What information have you sought for?
my lord, petitioner had submitted certain RT applications from the Boland University, my lord. Regarding some query about my lord on IS officer, my lord, without availing leave, my lord, he had got enrolled for PhD degree, my lord, without having any type of leave, my lord. So, my lord, his petitioner had sought for information, my lord. Subsequently, my lord, they have given some wrong information, my lord.
What is the interest of the petitioner?
He's a RTI applicant, my lord. RTI application can file by anybody, my lord.
Maybe. But why do you want certain information against the
Because the-
IS officer?
Yes, my lord,
What is
because,
your interest?
my lord, the interest is in, my lord, that university, my lord, was had already granted, my lord, PhD degree, my lord, without following the standing norms, my lord. There's a guideline, my lord, PhD guideline is there, my lord. It requires 70% attendance, my lord. But IS officer, my lord, who is a district magistrate, my lord, he is on service 24/7, my lord. How he could have got enrolled, my lord? Otherwise, every person could have got enrolled for PhD degree, my lord. That 70% attendance coursework is mandatory, my lord.
Who is the petitioner?
Well, petitioner is, my lord, presently, my lord, he is circle officer, my lord, under suspension, my lord.
Oh, she's a circle officer,
Yes, my lord.
suspended by the DC.
Yes, my lord. Not,
So
my lord.
now he wants
Because, my
information
lord-
about the DC.
No, my lord, that is separate thing, my lord. That is not my personal grudge, my lord.
Then
My
what
lord,
is your interest?
my
then?
lord, interest, my lord, I am interested on the Boland University, my lord. Because, my lord, I could have also got enrolled, my lord, without mandatory attendance, my lord, how I can put, my lord. Even, my lord, once an RT application is filed under 2000, sorry, my lord, under RT application, my lord.
Anyway, let's not go into that. The appeal is under section
19(3).
19(3). What does it say?
It doesn't give a time. There's
No,
no
my lord,
time
there is
limit to
time
that.
frame, my lord.
Only for the first appeal, there is a time limit of 30 days, which is up to maximum of 45 days. With regard to second appeal, there is no time limit.
First appeal lies before whom?
Before the same department in the higher officer, that is called first appellate authority, that can be designated as per the act. It could be anyone.
And
in
the
the
second
office.
appeal,
Before the State Information Commission, Lordship.
state information.
That is statutory body formed on the.
My lord,
And as on today, you are considering 2024 matter.
24, Lordship.
This appeal was filed in 2025.
There are two appeals, they are filed one in February 2025, one in May 2025.
Okay.
Both has been registered, however, not considered for a hearing as it is coming as a serial. And they have not shown any urgency for considering it, giving it a preference hearing, Lordship.
my lord,
They
kindly-
directly come before this honorable.
my lord, can I show, my lord, the section under which, my lord, the appeal was preferred, my lord, section 19, my lord.
19(3).
19(3), my lord, it provides, my lord, 19 and section 6, my lord, kindly see, my lord.
Have you
And
abstracted this section?
section 19(6), my lord.
Question is, have you abstracted the section in your book, in your writ petition?
Well, let's see. It is there, my lord, section.
It is there everywhere in the library, in the books. I'm asking you, is it not abstracted here?
But that specific provision not there, but appeal was there, my lord, under section 19, my lord. In the appeal itself, my lord,
You have not understood what I'm saying.
my lord.
You are referring to a particular provision,
Yes, my lord,
that under this provision,
my lord.
appellate authority is bound to consider appeal within some time frame.
Yes, my lord.
You should have annexed that you should have abstracted that provision in your writ petition.
Well, since it is already in the RTA application, that is why, my lord, I did not, my lord. But section 90, under section 90.
Instead of having to look at this book, if we could just turn the page in your writ petition, it would have been easier. That's what I'm saying.
Normally, my lord, yes.
Normally will not
It-
work
it-
here.
it
See,
would-
normally will
yes,
not
it-
work. Normally I
It could have
expect,
been better, my lord, dear lordship.
normally I expect the council to
Yes, my lord,
abstract
yes,
in the
my
book,
lord.
in
sorry,
in
yes.
your paper book.
Yes, yes, my lord, I appreciate that. my lord.
Supposing the book is not available here, then we have to search and look for the book. Please try to understand what I'm saying.
Yes, my lord. I appreciate that, my lord. Section 19(6), my lord. 24, page number 24, my lord.
Read.
My lord, 19 subsection 6, my lord. An appeal under subsection 1 or subsection 2 shall be disposed of within 30 days from the receipt of the appeal, or which such extended period not exceeding a total of 45 days from the date of filing thereof.
This is
As the
first
case
appeal. First appeal.
may- It is appeal under section 19, my lord.
Whatever it may be, it's first appeal,
No, it is second appeal, my lord.
second appeal.
Yes, my lord.
And where's the other appeal provision?
My lord, same provision, my lord. Appeal is under
Mr.
section-
Counsel for the,
Lordship.
you said that there are two appeal.
Yes, Lordship.
One
there's
is
two
under
kinds of-
the appellate, one is second appeal.
Lordship.
Where's that?
19, if Lordship comes back to 19 subsection 6, it says appeal under subsection 1 and 2, not under subsection 3, Lordship. Lordship will come back to subsection 3, second appeal against the decision of subsection 1. The appeal which is pending before us is the appeal which is under section 19, subsection 3.
Subsection 3.
3, yes. 6 only says about subsection 1 and 2, Lordship.
So come to page 89 of the writ petition. They simply say appeal under section 19.
However, Lordship, they have exhausted, it has to be, we are the second appellate authority, we cannot consider a first appeal.
No, show me the first appeal. Where's that? Any application here?
My lord. First appeal, my lord.
Lordship, it also says that in the reference of the same page number 89, Lordship.
84 is the appellate authority, my lord, that
The address to the, they
order,
have
my lord.
already
80
filed on first appeal, Lordship. In
No,
the
you say that there are two appeals.
Yes, Lordship,
Where's the first appeal?
19-1. As in the
In
copy
the
of the
paper
first-
book,
paper, page number,
copy of the appeal, where is it?
first appeal.
For instance, you take CPC.
Lordship,
First appeal, 96.
Lordship,
Second appeal under section 100.
yes, Lordship.
And in, you file an appeal, you just say an appeal under CPC. We don't know what it is. Whether it's first appeal or second, we don't know.
Lordship,
Similarly, out here also, you just mention appeal under 19. Under 19, you have both the first appeal as well as the second appeal.
Lordship. In this,
Well,
in the reference,
appeal-
they have written about the
So you
first,
have to be specific, and you're saying that this is a second appeal.
yes, Lordship, because the-
Where is the first appeal? Show me.
because the, Lordship, the reference says RTI file for information under RTI Act addressed to the first appellate authority, Lordship. And we being the second appellate authority and there having been a reference, we will consider it to be a second appeal, Lordship.
No, that's a different thing. You consider it as what or not, I don't know. But you must show me where is the first appeal.
But law, I didn't make-
If there is no first appeal, this will be a first appeal.
But there is a reference to the first appeal, Lordship. They have not,
But you show me, you are the counsel for the commission.
we'll only have the copy that is submitted to us.
No, you should say that they have already filed an appeal before this authority. It was rejected. Now it has come to the commissioner, which invariably is a second appeal. Both of you are not having proper instructions and you are submitting like that. Right. Learned counsel for the
Well, let-
petitioner
Lordship,
as the
speak-
respondent will show the court.
My lord,
Will-
16, my lord, page 69, my lord. 69
What is 69?
is the, page 69 is the first appeal, my lord.
It took 10 minutes for looking at the page
Sorry,
69.
my lord. Take the series of-
Wasting our time.
69.
This is 19-1.
Yes, my lord.
Then what is 89?
5924, my lord. The first app-
89 is under what section?
my lord, section 19(1), my lord. Subject, there is subject, my lord.
Where is that one?
Yes, my lord. 19(1), my lord.
Where is that one? At page 89. It's only 19.
19(1), my lord.
Oh, where is that one? It's not legible anywhere.
Page
Please
number
show me.
89.
My lord, the 69,
89.
I'm talking about 89, Mr. Counsel.
it was simply, my lord, section 19, my lord.
Simply said section 19, that's why. You already filed an appeal under section 19(1),
Yes, my lord.
subsection 1.
My lord.
And the act says that under subsection 1 and subsection 2, 45 days.
Yes.
Counsel for the commission says that under section 19(3), which is a second appeal, there is no time frame. So depending on the seniority we're considering.
Yes, Lordship.
So they're considering 2024 applications. Your application is the month of February and May.
Right.
It will come on its own turn.
Yes, Lordship. That is my instructions.
But if you both agree, we can dispose it of by
Yes.
saying that it should be disposed of
Yes.
at the earliest,
Yes,
preferably within a period of so and so,
yes, Lordship.
2 months.
2 months, Lordship.
Heard Mr. S. Hawk, learned counsel for the petitioner, and Mr.
D Deka.
D. Deka, learned standing counsel for respondent number 6.
Yes, Lordship.
Anybody else?
My lord, I'm for response number 1.
Also heard Mr.
KKJ.
K. Day for respondent number 1.
My lord, even otherwise also, my lord, on similar, same set of facts, the same person filed another writ petition that was dismissed, my lord, as he has no locus to file. When the writ petition is not maintainable at his estate.
We will not go into that.
That is separate, my lord. That is, his admission, her admission was contested, my lord. Why, how it is similar?
It is right. By filing this writ petition, the petitioner has projected his grievance that the appeal filed by, this is a lady,
Yes,
My lord.
filed by her before the
State Chief Information Commission.
State Chief Information Commissioner Assam in the month of February and also in the month of May has not been considered and disposed of till date. Stop. Mr. D. Deka on instructions submits that there is no specific time frame prescribed for considering and disposing of a second appeal under the Right to Information Act 2005. Full stop. The commission at the present is considering the appeals filed in the year 2024. And that the appeal of the petitioner can only be considered as per its own turn. Stop. He, however, submits that if a direction is given by the court, the respondent authority would definitely comply with the same. Next para, considering the above submission and without expressing anything on merit, the writ petition is disposed of by directing the second appellate authority to consider the appeal filed by the petitioner in the month of February and May 2025 as expeditious as possible and preferably within period of 2 months from the date of receipt of a certified copy of this order.
Highly obliged. Your Lordship.
Writ petition stands disposed of.
Obliged.
The in view of the order passed in the writ petition, I stands disposed of.
Item 5,
May I please your lordship?
Lordship, in this case, we have received instruction, Lordship. We are going to file a short affidavit in this matter. Already appointment has been done, Lordship, in all posts, Lordship.
Short affidavit
Short
only.
affidavit will file.
Short affidavit will do.
The issue is simple, your lordship. There need to be a Assamese as a subject in the graduation, your lordship, while document verification have taken place, your lordship. Initially, I did not submit, your lordship, my part 1 and part 2 BA marksheets, your lordship. As a result, your lordship, that I have the Assamese as a subject, your lordship, that was not there, your lordship. So they initially rejected me, but immediately thereafter, 1 day thereafter, your lordship, I submitted those marksheet. And if your lordship sees the letter, your lordship, at page 50, your lordship, the inspector of schools, who is the authority who verified the documents, your lordship, she admittedly said that I have subsequently submitted, your lordship, but they did not consider it, your lordship. Number one, your lordship. And
Yes.
when they did not consider it, your lordship, and ultimately, your lordship, they have declared the result and I am shown as, your lordship, not qualified, your lordship. My case is this, your lordship, I am under PWBD category, your lordship. That, your lordship, having the qualification and producing proof thereof are two different aspects of the matter, your lordship. The qualification and the subject Assamese were there, your lordship, in graduation, your lordship. Somehow, your lordship, on the date of document verification, I could not submit it. And the,
Okay,
and
he wants to file affidavit.
the lordship,
When can you file affidavit?
Within 10 days, lordship.
10 days.
10 days.
your lordship may fix a date, your lordship.
Art Mr. S. Thakur, learned counsel for the petitioner, and Mr. PP
The PP dot.
Datta, learned standing counsel.
The government India can take this.
This is secondary education.
That's it.
Issue notice returnable by 10 days. Give a date, please. 3/12/2025.
After 5, lordship.
Why?
I'll be out of it till 5.
After 10 days, your lordship.
8/12. So Mr. PP Datta submits that he has received the instructions and will be filing the affidavit within a period of 10 days. List accordingly. Respondent to file the affidavit so that the matter can be taken up for final disposal on the next week.
Notice maybe it is lordship.
Notice issue kori.
Issue.
Oh,
I
Deeply
can-
obvious.
Mr. Datta, just a minute. You accept notice on behalf of which respondents?
He can take on behalf of
All.
all of it.
I said issue notice of motion,
Notice issued, lordship.
returnable by so and so, then Mr. PP Datta accepts notice on behalf of all the respondents. And therefore no formal notice required. You want extra copy?
No.
Yes.
My lord, in this case, I was asked to take instruction, my lord. The petitioner has challenged, my lord, an advertisement for selection to the post of Vice Chancellor of Assam Agricultural University. So, my lord, on the ground that, my lord, the prescription under the Assam Agricultural University Act does not, my lord, conform with the UGC guidelines, and UGC guidelines are having, my lord, overreaching effect, my lord. So, I was asked to take instruction, my lord. My instruction from His Excellency, the Governor of Assam, my lord. He is the Chancellor of the university also, my lord. Is that, my lord? Actually, they say, my lord, the entire matter has been, my lord, referred to the government for taking a decision, my lord. Says only forwarded to the government for taking necessary action. So, if
So what is to be done?
my lord, they have challenged the selection process of Vice Chancellor of a university.
No, not yet, isn't it? It's only the composition, I think.
Yes,
Exactly. That
composition, your
composition is
lordship,
challenged
obviously there.
on the ground that it doesn't tell you with the, my lord, UGC guidelines. So if my learned friend, my lord, agrees, he has filed an application, representation before the authorities. Since the Governor House has informed that the matter is forwarded to the government for examination. So
So
that
governor is a party here or was vice chancellor?
as Chancellor, my lord,
Chancellor,
as Chancellor.
Chancellor.
So from the Chancellor's, my lord, office, I have been informed that matter has been forwarded to the government for taking a decision, my lord.
In that view of the matter, your lordship, let my representation be, your lordship, disposed of by considered by the government, your lordship, and till then, your lordship, the selections should be. There
If my
should
lord
not be-
directs for my lord consideration of his representation, the question of stay doesn't arise because without considering that representation, nobody will, my lord, proceed.
Then,
If there
then
is an
your
order
lordship-
from your lordship to consider the representation, as my lord, separate interim order is not required, my lord. definitely
that will be necessary, your lordship, because your
But
lordship.
Online will be required.
Lordship,
Representation will be considered independently and he will proceed independently. Can it happen like that?
lordship.
It
No,
has to
that is
follow.
what I'm saying. That is what I'm saying.
That is why we'll make it clear
My lord.
so that you don't get any ideas.
My lord.
Lords.
Then may I pray one thing, my lord? That
Yes.
that consideration should be the time frame. There should be a time frame to consider, my lord.
Yeah, how much time?
3 to 4 weeks, my lord, maximum.
All right, Art Mr. S. Thakur, learned counsel for the petitioner, who submits that the petitioner is aggrieved with the composition of the selection committee for the position of Vice Chancellor of Assam Agriculture University. Stop. On 14/11/2025, Mr. P.N. Goswami, Standing Council of Assam Agriculture University
27.
was asked to obtain instructions in this regard. Stop. Today, he submits that the governor is also the chancellor of the Assam Agriculture University, and he has been instructed to the effect that the matter has been referred to the state government
My lord.
for
Consideration,
consideration,
examination,
for examination and consideration.
my lord.
To stop. He also submits that the petitioner, in fact, has submitted a representation in this regard, and therefore the respondent authorities may
It's 32 need.
27.
be given liberty to consider the same.
Yeah, from Palawan separately.
To stop, Mr. S. Borthakur, learned counsel for the petitioner, submits that he has no objection to such a suggestion, but submits that the consideration may be done. Submits that pending such consideration and disposal of the representation, respondent authorities should not proceed with the selection process. Stop. Upon hearing the learned counsels for the parties, the writ petition is disposed of at the motion stage with a direction to the respondent.
Well, one thing, well, the representation is at page 27. It was addressed to the commissioner secretary, the governor. My lord. So now since the governor house has sent it to the government, let him file a representation before a secretary to the agriculture department.
27, page.
27 was the earlier representation. Well, let the petitioner file one more representation before the secretary agriculture department. Well, because since it is already with the government, well, it was dispersed to the commissioner secretary, the governor.
Okay, what did I say last night? That with a direction to the petitioner to file a fresh representation before the
Respondent number 2, my lord. Page 3.
secretary to the government of Assam, Department of Agriculture. Bracket respondent number 2.
Copy to Bhatnagar mark. I will go to the airport register.
Within a period of
4 days, your lords.
seven
week.
within a period of 1 week from today. And the respondent number 2, upon receipt of the same, shall consider and dispose of the representation by way of a speaking order within a period of 3 weeks
3 weeks. my lord.
on the day from the date of receipt of the representation. To stop until such until the representation is disposed of as directed herein above, the respondent authority shall not proceed,
Finally,
shall not finalize the constitution of the selection committee for the post of Vice Chancellor of Assam Agriculture University.
one more thing, my lord, I am appearing as additional agent, my lord, not standing or selling.
Okay.
Not
In Goswami will be as additional advocate general.
obliged. my lord.
7.
Notice may be issued at this stage.
Why?
My lord, the petitioner.
What is your case?
Pension, my lord.
Your
As a-
entire
as a-
case is on
as a
for notice.
Dependent unmarried daughter, my lord. Due to death of his father, who was a LP school head pundit, my lord.
Heard Mr. D. Bora, learned counsel for the petitioner, issue notice of motion returnable by 4 weeks. Mr.
I'm J. Sutia for 6, 7, and 8.
G. Sutia, learned counsel, appears for respondent number
6, 7, and 8.
6, 7, and 8, and Mr. S. K. Mehdi, learned
I'm for
counsel,
9.
appears for respondent number 9.
Respondent three, your
Ms.
lordship.
R M Barua for respondent number 3. Mr. P K Bora for respondent number 1, 1 and 4. And S Kuar for 2 and 5. You got it? Okay. Petitioner to serve requisite copies of the writ petition to the Learned Council appearing for the respondents today within 2 days. List again after 4 weeks.
Within 2 days. Right.
Item eight.
Please, your lordship, the matter related to the provincialization and service of the petitioner lordship. His name was earlier dropped as the enrollment of the student was only shown as 9 lordship instead of 10 lordship. Thereafter, his case was examined and secretary to the Assam Higher Secondary Education Council has prepared a report lordship by showing that in 2016, the enrollment of the students was his case was recommended by the DSC lordship. And after the recommendation lordship, his again the independent authority has re-examined the case of the petitioner lordship and prepared a report. Lordship, kindly see the annexure lordship. 12.
Yes.
13 lordship.
Will you
Page
notice at this
63.
stage?
Yes, yes.
All right,
notice
Miss-
will go.
And lordship, I have a similar similar person appeared before this honorable court, and the honorable court disposed of the said petition lordship. Kindly pass this same order lordship, similar order.
You are seeking disposal?
Yes, lordship.
Disposal of what?
What?
Kind of.
Direction was given to place the petitioner's case in the next joint sitting of the finance department meeting lordship. And accordingly, his case was placed and his name was recommended lordship. I have a similar prayer lordship.
Regarding similar pair losses, I have to take them. Then notice should go at this stage lordship. Next date lordship may kindly consider.
The notice is not required lordship.
Art Miss P. Saharia, learned counsel for the petitioner, who submits that by filing this writ petition, the petitioner has paid for a direction to the respondent authorities concerned to provincialize the service of the petitioner as postgraduate teacher in economics at Borbari High Secondary School, with effect from 30/11/2021. Similar to the other teachers who have provincialized. Right order dated 30/11/2021. Give me that order, which is that
Yes,
also.
lordship.
Stop. She also submits that the case of the petitioner is squarely covered by an order passed by this court.
The first order was passed in WBC 2387. On the basis of the said order, the second one is passed lordship, 1619.
Passed by this court on 29/8/2025 in WPC number 2387 of 2025. Open bracket, Ashad Ali, Take and 6 others versus State of Assam and others. These are different cases.
No, lordship, similar cases. Their name is
Similar in the sense that it is regarding provincialization, but
But-
here the verification lordship, the director has already written to the concerned district commissioner for verification. Those things have to be here lordship. And that is,
Mr. Chisti, don't
Yes.
worry, I'm not disposing it out.
yes.
I'm just recording us.
but lordship,
Yes.
kindly see the page
Madam,
six-
just tell me,
60.
the petitions are different, isn't it? These are not the same petitioners.
Yes, lordship.
It's
it is-
two different cases on
Yes.
similar issue.
Yes,
Yes.
Say that. Then you write, and also write order dated 15/9/2025 passed by coordinate bench of this court in WPC number 1619 of 2025. Open bracket. Dimba Hazarika, B, Dimba Hazarika versus State of Assam and 3 others. Next, in view of above, issue notice of motion returnable by 3 weeks. Mr. SMP Chisti, learned standing counsel.
Second,
Secondary education accepts notice on behalf of
1, 2
respondent
and
first.
3.
1 and 3.
1 and 3. 1, 2 and 3 and 4 is the government.
Okay, 1, 2 and 3. And Ms. Esquar for respondent number 4.
DC.
Extra copies within 2 days.
I do put here.
Uh, learned counsel appearing for the respondent shall examine the similar, examine the reliance placed by the petitioner to the case of Dimba Hazarika and Ashad Ali Sheikh and others to PRAF and make the submissions by the next day. You look into it, we'll see here.
Okay. Item 9.
May I please, your lordship? Matter pertaining to compassionate appointment, your lordship. The service holder died in harness on 14/6/2016, your lordship. The petitioner preferred an application for compassionate appointment
Who is that? Father?
on 10/7/2016.
Petitioner's father died.
Yes,
What was he employed as? A
he was
teacher?
employed as an assistant teacher
Okay.
in a high school at Morigaon. And I preferred my application on 10/7/2016 within the stipulated time. My application is at page 36.
Then what happened?
Then, your lordship, this application was placed before the DLC on 7/10/2017. Thereafter, my lord, there was no action taken by the DLC. I had thereafter approached the DC of Morigaon. I had filed an application on 9/9/2022 before the DC, which is at page 50, your lordship.
So DLC did not sit. Oh,
Ultimately, my lord, in the year 2024, your lordship,
DLC sat
DLC sat they convened a meeting
for the first time,
for the first time.
considering your case. Not
Yes,
before that.
not before that.
Okay.
To consider long pending applications of many people, my lord. And this, after they convened the meeting, your lordship, they prepared a selection list, cum rejection list, my lord, which is at page 51. They have given the vacancy, and at page 52, serial number 1, on top, he's the only person who was selected. And my name appears at page 53, serial number 6. And the ground for rejection has been given as application rejected as period 2 years over by relying on the OM of 2024. Now, this OM of 2024 has been challenged in the writ petition of 342 of 2025, along with many other writ petitions. And there was an order passed in WPC 342/2025 that cases prior to 1/4/2017, they have to be considered as per the guidelines before 1/4/2017. Now, that is not a binding precedent, and I have made that statement in my writ petition. But my factual matrix of my case is very similar to that case, my lord. I have also impugned the OM of 2024, which has done away with the OM of 2015, your lordship.
The OM dated 18/9/24
Yes,
was challenged, isn't it?
yes, it has been impugned by me, yes.
No, earlier by others.
Others also it was impugned, but the honorable court did not pass any order to set aside the OM. In WPC 342/2025, the honorable court did not interfere with the OM.
So it stands as on today.
Yes, that is why I have challenged it again, my lord.
What is the prescription of this OM? That
If you look, I have annexed the OM, my lord. It is at page 56. As per page 57, last para, in view of the circumstances mentioned above, it has been decided that no cases for appointment on a compassionate ground to the family member of state government employees who died in harness or retired prematurely on being declared permanently incapacitated for service or missing and whose whereabouts is not known prior to 31/3/2017 shall be entertained by any administrative department, authority for any reason whatsoever, nor to be placed before SLC DLC for recommendation of candidates for appointment on compassionate ground. Basically, the entire compassionate appointment policy has been done away with.
correct. So your case is covered. Your father expired in the year 2016.
16, yes.
And they say that prior to 31/3/2017 will not be entertained.
Yes. Yes. That is why I have challenged it.
Now, not only you, others have challenged it also, but
Yes.
this OM was not interfered with.
OM was not interfered. I have the judgment, may I please?
And instead, court had directed that all pending cases be considered.
Yes.
And pursuant to that, there was a notice issued by the personal department that you give your particulars within
15th of
Fifteen-
September
15th of September 2025.
Yes,
What did you do?
15th of September 2025.
You are not aware about that notice.
The notice.
That
was
notice was not given to me, your lordship, because my application was rejected. I have,
So
No,
it was not personally given to anybody. It was a notice in the papers, I think.
it was on electronic media also, Lordship, and published on 30/8/2025.
And your rejection was in which 24?
yes,
30/11/24.
But rejection on because of that OM,
yes,
correct?
yes, yes.
But you had the liberty to submit your particulars
I had already submitted my particulars
when?
on 10/7/2017, 10/7/2016
No, no, no.
to resubmit.
Resubmit.
I
In
did
terms
not
of
re-
that, in terms of that notice.
This was the notice.
I did not resubmit, your lordship. As per instructions,
So,
I did not resubmit.
we have come across many cases in
Yes.
which similarly situated, but they had submitted on the last date or before the last date. So we
Madam.
say that it may be considered.
And that's it.
But your case is a bit different. You have not abided by that notice.
No, I was not aware of this, my lord. Because of the rejection list, my lord, I have considered myself rejected, my lord. That's why I've approached the honorable court.
No, because it becomes a never ending process, you see. Again,
One
tomorrow
chance
some
may be
others
given
will
to
come
me to comply
saying
with
that
this.
I also was not aware.
My lord, that is
So not aware will not be an excuse for everyone.
just one chance, my lord,
No,
may be
how-
given to me to comply with this notice, your lordship, because I have filed my application way back in 2017. If I had to file it again, obviously I will file it again, my lord.
No, it was filed, but it was rejected, isn't it?
Yes, your lordship.
So when was it rejected? When did you come to know about this?
My lord, this was published on 22/1/2025. But I came to know sometime, my lord, later.
No, DLC met on November 2024.
Yes, but they published the list on 22/1/2025,
From where you get the date?
page 55.
Page 55. No, this is a part of the DLC minutes.
Yes. It became available in the public domain after signing off by the DC and was signed on 22/1/2025.
Correct.
So after that, I was able to find out that I was rejected.
Now
by-
we're in the end of the year. In the meantime, many things have happened.
Yes. The long pending application, my lord. I've complied with every guideline, your lordship, save and except this last portion, my lord.
No, you have also taken your own time. This is the first rate petition.
First,
You have never come. You submitted your application in the year 2016,
yes.
July 2016. Thereafter, you just kept quiet.
Thereafter, I approached the DC. I filed an application again in 2022.
No, you have gone to the maybe authorities here and there, but you never came to the court.
I never came to the
Why
court.
do you come to the court now? After
Because,
some-
my lord, the rejection list was published on January 2025, my lord. They never convened a meeting, your lordship.
See, your writ petition also affected by the principle of immediacy.
My lord,
2016, somebody in the family dies.
my lord.
You are left without support. So under such circumstance, government has formulated the compassionate appointment. Team. But it cannot run for years and years together.
My lord,
Which goes to show that you are able to sustain yourself.
but delay is not on my part, my lord. Delay is on the part of the department, my lord. I can
Delay
show
is on
by
your part
judgment
to
of the
come
Honorable
before the
Supreme
court.
Court, my lord.
So within 2018, 19, 20, you should have come, say, what is this? Till now, you have not considered a direction be issued to them. You should have done that. You have come only after such a long time. So on that ground, I think we cannot entertain your writ petition.
Okay.
My lord, may I just read one judgment, my lord. Recent judgment of the
What
Honorable
judgment?
Supreme Court, where there was the factual matrix is very similar to my case, my lord.
Then
Yes, this one. This is a judgment, my lord. It's reported in AIR 2022 SC 2836. The factual matrix is very similar, my lord. The department did not act on the application for a period of 10 years, my lord. And the honorable court, honorable Supreme Court has held, my lord. Thus, from the aforesaid, it can be seen that there was no fault and or delay and or negligence on the part of the appellant at all. The application was not preferred for 10 years. Then he approached the High Court, my lord. He was fulfilling all the conditions for appointment on compassionate grounds under the 1990 rules. For no reason, his application was kept pending and or no order was passed on one ground or the other. Therefore, when there was no fault and or delay on the part of the appellant, and all throughout there was a delay on the part of the department authorities, the appellant should not be made to suffer. Not appointing the appellant under 1990 rules would be giving a premium to the delay and or inaction on the part of the department authorities. There was an absolute callousness on the part of the department authorities. The facts are conspicuous and manifest the grave delay in entertaining the application submitted by the appellant in seeking employment, which is indisputably attributable to the department authorities. In fact, the appellant has been deprived of seeking compassionate appointment, which he was otherwise entitled to under the 1990 rules. The appellant has become a victim of the delay and or inaction on the part of the department authorities, which may be deliberate or for reasons best known to the authorities concerned. Therefore, in the peculiar facts and circumstances of the case, keeping the larger question open and aside, as observed herein above, we are of the opinion that the appellant herein shall not be denied appointment under the 1990 rules, my lord. So this, my lord, aspect should be considered, your lordship. This is a recent judgment, my lord. There has been delay, my lord. Delay has been caused by the department, your lordship. I am economically deprived, my lord. I have an annual income of 40,000 rupees, my lord. I prefer the application as per the compassionate appointment policy in force at the time, my lord. They were not acting upon it. I filed an application thereafter in 2022 that my application is at the very last stage, but I have not received any recommendation. That application is at page 50, my lord. I approached the DC, my lord. As per 2015 policy, my lord, I have a strong case, my lord.
So you approached the DC was in 2022.
Yes,
Then you approached this court in 2025.
2025,
And your application is in 2016.
2016.
Let's see, so much of time has flown in between. I don't think we can entertain your writ petition. I'll have to pass the orders. Because the judgment you just read would be,
May I place the judgment, my lord?
it will be applicable to the peculiar facts and circumstance of that case.
I read para 7, my lord.
Just a minute.
In this case, your lordship, he filed the application for compassionate appointment in the year 2010 or 11, my lord. And he filed writ petition in the year 2020, your lordship. Before the court, before the Orissa High Court, my lord.
Facts are slightly different in this case.
My lord,
The judgment which you're relying upon,
my lord.
the new rules came, see, pending consideration, the old rules was replaced by new rules.
Yes, just like my,
Earlier, you could have aspired for the post of junior clerk. But with the coming to force of the new rules, you can only aspire for the base post, which is Group D post.
yes,
So that is why the petitioner had gone to the High Court, which was rejected, then the Supreme Court passed their order. But your case is different. It has been considered already. And before consideration also, there was delay on your part, not coming before this court. You had gone to the DC and you are satisfied with that. Ultimately, when the matter was taken up by the DLC in November 2024, they rejected your and which was accessible to you by January, but now you have to come in November. So all these things contribute to gross delay and negligence. On that ground, we'll has to fail.
my lord.
All right. Third, Mr.
HK Borua, my
K.
lord.
Barua, learned counsel for the petitioner. And Ms.
S4,
Escobar, learned
2, 3, and 4.
government advocate
Yes, Lordship.
for the respondent,
2, 3, and 4, Lordship.
numbers 3 and 4. And Ms.
1, Lordship.
N.M. Sharma for
Secretary Education Department, 1 and 4.
The-
1 and 5, Lordship.
respondent, Secondary Education Department.
Lordship.
Of having regard to the projected case of the petitioner, the writ petition is taken up for disposal at the motion stage itself. It is the case of the petitioner that his father was employed as an assistant teacher in Chabuk Dhara High School. Situated at Itakali Chapuk Dhara village under Bhurbanda block of Moregaon district. And he died in harness on 14/6/2016. To stop. He being the sole breadwinner of the family and the petitioner being unemployed. The petitioner submitted an application for compassion appointment on 10/7/2016. Before whom did you file your application?
Before I filed Inspector of Schools, my first application.
Before the Inspector of Schools, Moregaon District. While the petitioner was waiting for the consideration of his application, since no steps had been taken to his information, the petitioner submitted a representation before the Deputy Commissioner Moregaon on 9/9/2022. stating that he has come to learn that his application has been rejected and therefore prayed for reconsideration of his application as there was no earning member in his family. To stop it, so turned out that the application of the petitioner at the relevant time was not yet disposed of. And his case came to be considered in the district level committee meeting held on 29/11/2024. In the conference hall of the Deputy Commissioner's Office, Goregaon, wherein the petitioner's name appeared at serial number 6 of the meeting minutes. With a remark that the application was rejected since the period of 2 years as per principle 10. What's the principle 10? As period of 2 years had lapsed as per principle 10. And also in view of the office memorandum dated 18/9/2024. Full stop. Be it stated herein that the office memorandum dated 18/9/2024 was issued by the Personnel B Department, Government of Assam, notifying that the appointment on compassionate basis is being done away with in view of the introduction of the compassionate family scheme, compassionate family pension scheme. Full stop. The office memorandum was put to challenge by a number of persons who were aggrieved, and all the writ petitions were disposed of by a common order. We have that common order
Yes.
dated
Starts from page 70.
3/4/2025. And the lead case being WPC number 342 of 2025. Stop this court without interfering with the office memorandum dated 18/9/2024. Directed that all the pending cases for compassionate appointment be considered as per the relevant guidelines and policy of the state government. To stop. The said order was passed as per the consent of the rival parties concerned. Stop. Pursuant to the said order, the Personnel Department issued a notice on
38/2025.
38/2025, inviting all concerned and interested to submit their particulars for compassionate appointment on or before 15/9/2025. To stop. It so appears that the petitioner in the instant case has not submitted his particulars. In terms of the notice. Claiming that he was unaware about the same. Now, it may however be seen that the case of the petitioner was not pending consideration as on the date of the said order, that is 3/4/2025, and that his application was rejected by the DLC, which met on 29/11/2024. Stop. It therefore only appears that the petitioner petitioner, you got that. It therefore only appears that the petitioner, the writ petition is hit by delay in latches. So in other words, the application was filed by the petitioner on 10/7/2016. And although he submitted a representation before the Deputy Commissioner Morigaon
(9/9/2022).
on
Page 50, my lord.
on 9/9/2022, he did not approach this court. To stop. Further, the DLC minutes dated 29/11/2024, by which his application was rejected, although notified on 22/1/2025. The instant writ petition has only been filed on 3/11/2025. Stop. Next para, the learned counsel for the petitioner has also relied upon the case of Malaya Nanda Sethi versus State of Orissa and others. Reported in AIR 2020, 2022 SC 2836. To contend that delay is attributable to the respondent authorities and for which reason the petitioner should not be penalized. To stop, it is however seen that in that case, the applicant had submitted an application for compassionate appointment to the post of junior clerk. And during the pendency of his application, the rules for compassionate appointment had been replaced by new rules wherein family members of the deceased person could only aspire for a Group D base level post. To stop, the respondent authorities did not consider the application of the petitioner therein until the rules, no, and that the rules came to be replaced by the new rules. To stop, it was under such circumstance that the apex court was of the view that the delay was on the part of the official respondents in not considering the case of the petitioner oblique appellant while the old rules were in force. Stop, accordingly, under the peculiar facts and circumstances, relief was granted to the appellant. Stop, however, in the instant case, the petitioner, apart from filing his application on 10/7/2016, did not follow up the same, except for filing one representation before the Deputy Commissioner Morrigan on 9/9/2022. Now, thereafter, when his application was considered and rejected by the DLC, which met on 29/11/2024, the petitioner has come to file the instant writ petition only on 3/11/2025. Stop. Under the facts and circumstances, without expressing anything further on the merit or otherwise of the case, the writ petition is found to be not maintainable on the grounds of delay lattice. Accordingly, the same is dismissed.
Objection.
Item 10.
May it please your lordship. Petitioner before lordship praying for basically two pair, my lord. One pair, my lord, the area salary with effect from 1/4/2018 to 28/2 2022-23, and second pair is allotted to the respective GPF account, my lord. Before going to that, my lord, your lordship go to the, my lord, all petitioner initially appointed a stipendary teacher and their service was regularized in 2018. But effect from 2018, whereas they completed basic training before 2005. So they came before the honorable court. Please may kindly see page 114, my lord. 114, my lord, Annex 13 and operative portion, my page 118, my lord.
What is 114? Earlier round.
My lord, earlier round, my lord.
How many times you've come? Second time.
Second time, my lord. My lord, your lordship, they complied with, but partly complied with, they came before the honorable court. Page 118, my lord. As regards fourth para, your lordship, got it, my lord. As regards this claim, it has been submitted, the authorities has already declared those teachers who are passing junior basic training course before 25/1/2005 shall not be covered under new pension scheme as evident from the order dated 15/3/2010. Accordingly, this court is of the view that since the petitioner had obtained their junior basic training 2002 before 25/1/2005, their case also covered the old pension scheme and not by the new pension scheme. With the above observation, direction present petition stand allowed, respondent right to make payment so and so. And thereafter, my lord, the commissioner secretary, joint secretary pass an order, page 119, my. Second paragraph, my lord, fourth line, my lord. May I read, my lord? Second paragraph, fourth line, my lord. The Honorable High Court had order dated so and so disposed of by the directing the respondent authority to make payment terms of the pay scale attached to the post of along with area to the petitioner. In regards to them, old pension scheme Assam, the Honorable High Court is of the view that since the petitioner had obtained junior basic training course in the year 2002, there are case also covered by old pension scheme. In view of the above fact, it is observed that since the benefit claimed by the present petitioner had already been extended to the similar situated court each petitioner, therefore you are requested to kindly comply with the Honorable High Court order so and so and allowing regular pay scale to the instant petitioner with effect from their passing junior basic training along with area till order regulation as well as allowing them to govern under old pension scheme. And thereafter, my lord, they are all receiving the area salary with effect from 2004 from the date of passing junior basic training. But thereafter, my lord, but next page, my lord, which I came before the honorable court, the first pair, my lord. The Annex 15/120, my lord. That this was Deputy Inspector of Schools, submission of statement, particular allotment of General Provident Fund account number with to the director. With reference to the subject side, I have the honor to forward with the statement, particular allotment of General Provident Fund account number 9 extended in this regard, like to hide their reference created so and so. Therefore, requested to kindly allot GPF account number. Above mentioned 9 number extended LP should kindly in my lord. And the next page, my lord. Next page, Annex 16, my lord. That is the proposal area with effect from my lord. Your lordship, second priority. Block Elementary Education of Kaila has submitted proposal for requirement budget payment of area of salary to 8 teachers, period of 1/4/2008 to 28/2/2023. So and so, that was not released, my lord. And that is pending before the honorable court, my lord. And District Elementary Education Officer also forwarded page 129.
So area salary not given to you?
Yes, one area particular period before all are receiving, my lord, from 2004 to 2008. Just, my lord, we are not receiving area salary. 1/4/2018 to 28/2/2023.
This one you have not received?
Not received. And on the other hand, GPF account was not allotted by the director, my lord. Page, my lord, 120, my lord. That was pending before the director, my lord. That may be considered by the authorities. This is my peer, my lord. Page 120, my lord.
There are 9 petitioners.
9 petitioners.
This document speaks about 8 teachers only.
nine other is also there, my lord. Next page, my lord, we have. Next one is separately, page 129, man. One is separately, 8 is same, man.
So some communication is going on
Yes, my lord.
between the department.
Yes, my lord. So at the
So at this stage, is
take
it not,
instruction as to at least GPF account were not allotted by the director, thereby our money was not deducted. Already government has passed the order, we have old pension scheme, my lord.
government has passed the order means this phase 119.
Yes, my 119. Last, and the allowing, last para, my lord, before that, my lord, fourth line, and allowing regular pay scale instant repeat with effect from date of their passing junior basic training and area till the order of regulation, as well as allowing them to govern under old pension scheme, my lord.
Correct. So this is there. Yes, what do you say?
Notice may go, my lord, because communication of 3rd July 2025, my lord, some coordination is going on.
Please write, Hart, Mr.
And Bora, my
And Bora Learned Counsel for the petitioners who submits that this is the second time the petitioners are before this court. Top the other writ petition being WPC number 7831 of 2019 was disposed of. White order dated 30/10/2019 by directing the respondent authorities to pay
page 118, my lord. Fourth line, man.
the petitioners their respective pay scale along with area salaries. Stop. It was also directed that the petitioners would be covered by the old pension scheme. Since they have passed their junior basic training course before 25/1/2025. Full stop. Pursuant to the same, although the state government in the elementary education department had informed the director of elementary education on 30/11/2021 to accord regular pay scale to the petitioners with effect from the date of their passing junior basic training along with areas. And also allowing them to be governed by the old pension scheme. The petitioners have not been allotted any GPF account till date. And the area salaries from 1/4/2018 to 28/2/2023 amounting to rupees 88,83,166 has not been paid. What about the other one? One
Other
more.
page 129, man.
This is for one person
1%. Man.
in respect of the eight petitioners. Stop, okay? You all combine like that. Stop now. In respect of one of the writ petitioner,
Diganta Bhattacharyya.
an amount of rupees 10,79,480 for the same period remains unpaid. Stop. I agree. The petitioners are before this court once again. Issue in view of above issue notice returnable by 3 weeks. Mr. P.K. Bora, Learned SC Elementary Education accepts notice on behalf of
1 to 5 months.
respondent numbers 1 to 5.
1 to 5.
R.M. Barua for respondent number 6.
Number 7.
S.K. Mehdi for respondent number 7. and Ms. Esquire for respondent number 8.
Respect for pair mile, only mile in GPF, maybe account may be open mile. It pays mile 120, that may be considered mile as an interim mile. Pays 120 mile.
Let us take instruction regarding this.
Specific order is there by to the director, which is pending before the director elementary education. Pays 120.
Also, if you notice on the interim prayer, returnable by 3 weeks. Respondents to, there's counsels for the respondents to obtain instructions by the next date.
Pendency is no.
Pendency will not be a bar for the respondents to grant the GPF account numbers to the petitioners,
Which is pending before the director, mile.
which is said to be pending before the director of
Elementary.
elementary education.
Marks.
Obliged.
That was item 10.
Item 11,
Mayor, please, your lordship. Hearing your lordship, the benefit of regular pay scale to the non-teaching staff of the provincial school has not been granted, your lordship. This case is covered, fully covered by Annexure 5, a judgment of the division bench, page 78, your lordship. Relevant, page 121, para 15 and 16, your lordship. Division bench judgment is fully covered. Page 121.
Yes. You want to read?
Lordship,
Would you like to read?
yes, yes. Mayor,
Or we issue notice at this stage?
no, it can be disposed of, it is fully covered by division
No.
bench judgment.
It may be covered, but we have to also hear the other side.
Hmm.
Who's preparing for the other side?
A school, a secondary education,
Secondary education.
a covered division bench judgment, non-teaching staff. It Abdul Muttalib and it covered division bench.
It is shown as element, that's why we have missed an item lordship, secondary indicated.
Secondary.
For this or elementary rekha hai sir. Aapne party ki thakun na.
No, it secondary.
My lord, party is secondary, in for this it is shown as elementary, that's why we have missed this item lordship. But they have met secondary as a party, at an 11 it is shown secondary element. And elementary also we don't have the file.
This is secondary, isn't it?
Yes, secondary. What is going on? Copy has been solved, but wrongly listed, is admittedly in the list.
Oh, you want to examine this? What is to be done?
Otherwise, it is covered, fully covered by division bench. Otherwise, or it may come on Friday, your lordship,
Will come on Monday.
Monday. Yes.
You are Mr. Lashkar?
My name is in the Okalatama, but it is not reflected in the call list. R. Majumdar.
Okay, Mr. R. Majumdar, learned counsel for the petitioners. For petitioner.
Petitioners. 22.
Petitioners submits that the case of the petitioners is squarely covered by the division bench judgment of this court
WBC C2.
dated 5/8/2025. Passed in WPC number
39
C9 of 2023.
and batch.
Which is the lead case. I said order, na? Before order, you write judgment covered by. You write covered by the division bench. And therefore may be disposed of in similar lines. Top next para, Mr. SMT Chisti, Learned Standing Council, Secondary Education. However, some is that since the name of Standing Council, elementary education has been reflected instead of secondary education in the cost list. He may be given some time to go through the brief. In view of above, list again on Monday. A registry to reflect the name of SC secondary education in the cost list instead of SC elementary.
Item 12.
May it please your lordship. Well, in this case, the recovery has been made after retirement of the petitioner. He's a teacher, my lord. He retired on, my lord, 31/3/2024.
Yes. After retirement, it's not permissible.
It is not permissible, my lord. The amount recovered, lordship will find.
No,
that
I think
pays-
there was some slot within after 3 years or something like that.
No, after retirement.
Or immediately after retirement cannot be
no,
recovered.
Not permissible.
Is it as per the Ajay Chaudhary?
My lord, Rafiq Masih.
I'm sorry,
Rafiq Masih,
Rafiq Masi. Rafiq Masi says that.
my lord.
Where's your recovery order?
My lord, recovery order, no recovery order has been passed. They have deducted it from my DCRG.
So where
That
is
is page 27, my lord.
where can it be seen?
Page 27, my lord. Column
Yes.
G, my lord.
Column
Power
G.
pay allowance, two
Column-
lakh 76,049 rupees.
Where's column G?
Page 27,
27, isn't it?
my lord.
In the middle, no.
D,
G, my lord,
G. Overpay,
my lord. That amount has been deducted.
overpay allowance. What is this regarding wrong fixation?
From DCRG, it has been deducted, my lord. While paying the DCRG, this amount has been deducted. At this stage, also may ask my friend to, my lord, take instruction.
It's like a director of pension notice,
Hmm.
not by the department. Director of pension, there is this order, it's in order. There will be, to the value of the Dhammaguhi. Page 27.
Being the amount admissible of what? DCRG.
DCRG.
But where do they write DCRG?
DCRG amount in the first column, my lord. DCRG amount is 11,99,025 rupees,
Okay, that's the one.
my lord.
So they deduct 27,
2,76,000.
2,76,000. Then total how much is to be received by you?
My lord, deducting this amount, my lord, I have received. To minus for us. It will provide to minus for. Hmm? my lord, that calculation they have made in page 22, my lord. Page 22, my lord, after,
11 lakhs is after deduction,
no, my lord,
before deduction.
before deduction. After deduction, it is, my lord, 8,32,000, my lord.
They should have mentioned that, isn't it?
The deduction was done by the treasury officer, after getting the letter from the pension department. So treasury officer has deducted, his receipt is prepared by the treasury officer along with.
No, what I'm saying is that they say DCRG. In this, they should have written 11 lakhs is the DCRG, but 2 lakhs something is deductible. So this is the amount payable.
They have not, no, in the,
Now, in the letter itself, they should have written payable amount is this much.
my lord, but in page 22, my lord,
Otherwise, you get the impression that 11 lakhs is after deduction.
my lord.
And column G, 2G, it says overpay allowance. So probably your pay fixation is wrong.
My lord.
Overpay.
Right.
You have been paid over.
My lord, they says that, my lord. They says that, my lord.
That's what they say. But anyway, whatever it may be, you say that this is not deductible.
This is not
Because
deductible.
ultimately, you may not have been personal liable for that,
Yes, my lord. My lord, what
for
happened?
fixation of your pay.
Initially, my lord, I was appointed in a fencing school.
Hmm.
School was provincialized. My post was dropped. Subsequently, my service was provincialized by giving effect, my lord, in the date when the other teachers were provincialized. That they have perhaps, my lord, calculated that I was not eligible for the salary for that particular period.
Okay. Now, the deduction is already done,
Deduction has been done.
already done. Who's paying for pension? Director of pension? Government. Where is the authority you're relying upon?
Response number 4, my lord.
No, the authority you're relying upon that it's not deducted, cannot be deducted.
Ajoy Kumar Chaudhary is there, my lord, Rafiq Masi, my lord, as well as, my lord, the
Rafiq Masi.
government notification, my lord, page
Sorry?
28,
28.
page 28.
This is as per Rafiq Masi only.
In terms of, my lord, Rafiq Masi, my lord, they have published this notification, my lord.
And
saying,
your case is covered by which paragraph?
my lord, paragraph 1, my lord,
You belong to which class? Class 3?
class 3, my lord, class 3.
Recoveries from employees belonging to class 3 and 4. How do you say you're covered by 1? One, what does 1 provide for? Any recovery cannot be made.
After retirement, my lord, it is
But he
not.
doesn't say after retirement. Para 2 says recovery from retired employees.
My lord.
Para 1 does not say anything about retirement. It says no recovery from class 3 and class 4 service.
My lord, para 3 also, my lord, para 3 also, my lord.
In excess of 5 years. In your case, there's no order.
There is
Only
no-
thing is that
there is no
deduction is
order.
made from the DCR.
Only deduction has been made, my lord. No order has been passed for recovery, my lord.
So paragraph number 3 says 5 years. Excess payment made already for 5 years.
My lord, if the excess payment was made, it was made in the, my lord, initial stage. Initial stage, at the time of provincialization of my service. Because, my lord, initially my service was dropped. Subsequently, it was regularized, provincialized. And after provincialization, my lord, effect was given with the other teachers when their services were provincialized. So, my lord, that is at the initial stage, not within 5 years of retirement, my lord.
So we'll have to hear the other side.
Yes.
What to
Yes.
do.
No, shit.
You are also supposed to tell us how you're covered by this OM.
My lord, the Rafiq Masi also, Lord, may kindly see.
Is poem only on second page, page 59 losses, second para. I think that is about,
Which one?
in that, notification, that is, access 6 page 29.
Second para.
However, in all cases where access given on account of non-paid fixation, grant of skill without due approval, promotion without following the procedure, or in excess of entitlement, etc., come to notice, immediate corrective action must be taken. So that has not been taken, I think, only. But anyway, Dr. Notice of this will examine everything also.
Paragraph 12 of Rafik Masih, my lord, guideline has been where the recovery is impermissible, my lord, that has been mentioned, my lord.
No, this office memorandum or this notification is also in terms of Rafik Masih.
Yes, yes.
Which paragraph in Rafik Masih you say?
Paragraph 12, my lord.
Paragraph 12. No, same thing has been highlighted here.
Same thing has been
Okay.
highlighted.
So it's copy paste only from Rafik Masih, this notification. Ahat, Mr. I.H. Saikia, learned counsel for the petitioner, who submits that the petitioner is agreed with the deduction of rupees 276049 from the death cum retirement gratuity to be received by him, since the same is in violation of the notification dated 27/1/2022, issued pursuant to the apex court decision rendered in state of Punjab and others versus Rafik Masih, etc. Two thousand
2015 4 SCC 334, my lord.
4 SCC 334. In view of above, issue notice of motion returnable by 3 weeks. Mr. SMT Chisti, learned standing counsel secondary, accept notice on behalf of respondent numbers 1, 2, and 3. While Miss
1, 2, and 3. So it can.
I forgot her name again, Miss Esquire.
Yes,
Learned government advocate, accept notice on behalf of respondent numbers. Respondent number 4. Miss R.M. Barua for respondent number 7 and 8. Score will be for what? 5 also? Score for 4 and 5. R.M. Barua for 7, 7, 8. And Miss A. Sharma on behalf of Miss Pete Chakravarti for respondent number 6.
5. 6.
Notice is therefore complete. Petitioner to serve extra copies within 2 days. List again after 3 weeks.
Also fix a date, my lord. Also fix a date, my retired employee, my.
On so and so, give a date.
10, 12,
Oblige, my lord.
13.
May I please, Lordship? My lord, the petitioner is the senior most assistant teacher of the Amalgamated Higher Secondary School, my lord. And he has been getting the graduate scale of pay since 1992. My lord, your lordship will find order of amalgamation annex 2, page 23. His service, his earlier school has been amalgamated with the Shivostan Higher Secondary School.
Now, what is the matter regarding?
Regarding, my lord, in charge principal. What happened in this case, my
Your
lord?
claim is on the basis of seniority.
Yes, sir, seniority, but the what happened, I have passed the B.Ed degree from Swami Vivekananda University, which is recognized by the NCT. NCT recognition at page number 30 and Annexure 6.
Any private respondent?
No private respondent, if charge is given to the inspector of schools.
Therefore, there is no private response.
Where is the charge?
Impugn order, your lordship will find at page
43.
43. An impugn show cause notice, your lordship will find at page 42. They have issued a show cause notice as per provision attracting the rules 13, but I have taken NOC from the department. NOC, my lord, page 32 and 33 is the NOC. While I was serving in the elementary education department, I took NOC from both district officer and the director, page 32 and 33. And this rule 13 comes only when the NOC is not taken prior to pursuing the qualification, education, higher education. This is on wrong footing, my lord, this impugn show cause notice is issued.
So NOC was given to you.
NOC page 32 and 33, my lord. 32 on my application in the left hand side, my lord, district elementary education officer has given. And page 33, official communication by the DE Assam.
Yes, who is appearing?
Lordship?
Respondent, anyone?
Respondent, I think, a secondary education department.
Secondary education.
And NCT is there, my lord.
Art Mr. B. Prokashta, learned counsel for the petitioner, who submits that the petitioner is aggrieved with the order dated 9/9/2025 issued by the Director of Secondary Education. Allowing the
Respondent number 3, my lord.
respondent number 3. That is
Inspector of Schools, Nagaon.
Nagaon District, to act as the headmaster in charge of Sibasthan High School, Nagaon, along with financial powers to draw and disburse salary, etc. So he submits that the petitioner was denied the opportunity to be the in-charge principal, headmaster.
Principal, my lord, amalgamated, after amalgamation, it has become higher secondary school.
Then why is it written headmaster?
Earlier, it was
In the impugn order,
impugn order, my lord, they have wrongly written. It is in charge principal. After amalgamation, school has become higher secondary school.
has been denied to act as the in-charge headmaster oblique principal of the school.
But you are giving the academic circle.
Academic charge I am holding is nothing.
Just setting holding the insert. The authority to decide lordship. When the authority.
It is not a question of interest, my lord.
It is temporary.
Today, we are not saying anything.
It is not a question of interest.
Purportedly on the ground that the petitioner did not obtain permission to pursue B.Ed course, and for which a show cause notice was issued to him on 9/5/2025. To stop referring to annexures 7A and 7B of the writ petition. The learned counsel submits that the petitioner was indeed given permission to pursue B.Ed course, and therefore the show cause notice issued to him is unfounded. So be that as it may, let the notice of motion be issued. Runnable by 3 weeks. Mr. SMT Chisti. SC Secondary accepts notice on behalf of respondent numbers 1, 2, and 3. And what about NCTE? Mr. I Alam accepts notice on behalf of respondent number 4. Notice is therefore complete. Extra copies be furnished within 2 days. List
In-
made after 3 weeks.
Interim observation will be given, my lord, pendency shall
interim?
not be barred. My lord, nothing is there in this, they are wrongly issuing show cause notice, my lord, without any basis.
You reply,
I have given reply, but therefore they have not
give your
proceeded.
reply, give your document.
They are
saying that-
objecting in the observation even. What is this, my lord?
Yes, next.
14.
May it please your lordship. Lordship, this is we are tutors, lordship, claiming our regular scale of pay, lordship. We have been, our services have been provincialized under the act, but we are given only a fixed pay remuneration of 10,800, lordship. So this is a covered case, lordship. Division bench judgment covers it. Mohar Ali Sheikh, which is reported in lordship 2024 5 GLT 689.
Have you annexed it?
Lordship, no, we have the
The order?
lordship.
No, what is this order that you have annexed here?
This is a earlier order, lordship, because we were appointed earlier as OBB teachers. So we were continuing in service, and the court had also ordered to pay us our salaries, lordship. Those orders we have annexed, lordship. Then in 2021, when the court asked government to provincialize our services by issuing so-called notices, then lordship, they reappointed us as tutors in January 2021, lordship, but they have paid our salaries since November 2020, lordship. So they have only given us a fixed pay, lordship. Although they have provincialized our services, they have given us only a fixed pay, lordship. So this earlier a batch of writ petitions were filed, and the division bench, lordship, has taken up the matter and has passed this order in Mohar Ali Sheikh, lordship, reported in 2024 5 GLT, page 689, lordship. And our case is covered by paragraphs 162 to 179, lordship. This batch of writ petitions on various grounds, it has been filed. So, lordship, this is the case.
Ms. Kaur, what do you say? You examine whether it's covered or not. No verification, all that liberty you have. No.
Lordship, we are tutors, that is to, we have annexed our appointment letters, lordship. And lordship, may kindly see paragraph 162 of the case I have mentioned, lordship.
No.
Is 747.
See, today we'll do one thing. I will give some time to Ms. Kaur.
Lordship.
Let her go through the judgment and
Lordship.
tell us whether it's covered or not. Then we'll pass the order.
Page 747, lordship, paragraph 162. There it's written, lordship, the first line, the next question that arises for consideration in this batch of writ petitions is pertaining to the remuneration of fixed salary paid to the tutors upon provincialization of their services, lordship. So it is pertinent to note herein that under the Act of 2000, lordship, these are discussed here, and thereafter in paragraph 179, lordship, they have ordered. It is true that the courts cannot direct the legislature to enact laws in a particular manner. However, in discharge of its statutory obligations, the government, in exercise of its rule-making power, will have a duty, lordship.
You just stay away from the microphone. Don't be too close because it's very loud.
Okay, I cannot hear myself. That is why, lordship, I thought. Okay. So while framing the rules, the state will also be under a bounden duty to not only to act in terms of the scheme of the act, but also to unflinchingly adhere to the constitutional norms of equality. It will therefore be in the fitness of things that the state government itself, in exercise of its rulemaking power under Section 23 of the Act, take necessary steps to provide for a regular pay scale to the tutors, which can even be commensurate to the pay structure indicated in the schedule of the governing act. Such a measure, in our view, will restore the equality of treatment to this category of teachers with the other government employees, and at the same time will not become burdensome to the exchequer. We therefore direct the respondents to initiate necessary steps in the matter in the light of the observations made herein above as expeditiously as possible, preferably within a period of 6 months from today.
Okay. Heard Miss
M. Bordeloi.
M. Bordeloi, Learned Counsel for the petitioners, who submits that the petitioners are aggrieved with the action of the official respondents in granting only fixed pay to the petitioners. Despite the fact that the petitioners have been already provincialized
Lordship,
in their
services
service
have been provincialized as tutors
as tutors
under the Assam provincialization of service rules,
under the Assam
Assam Education Provincialization of Services of Teachers and Reorganization of Educational Institution Act 2017.
What do you get it? Act of 2017. Gustav, she also submits that the case of the petitioners are squarely covered by the division bench judgment of this court rendered in Mohor Ali Sheikh and others versus State of Assam and another, reported in 2024
24 5 GLT.
5 GLT 689.
Relevant paragraphs 162 to 179, Lordship.
She also draws the attention of this court to the paragraphs numbers 162 to 179 of the said decision. Next para, in view of above, issue notice of motion returnable by 2 weeks. Ms. S. Kuar, Lanet, Government Advocate, accepts notice on behalf of all the respondents. Extra copies within 2 days. Ms. S. Kuar shall examine the division bench judgment and make her submissions by the next date as to whether the case of the petitioners can be disposed of as a covered case. List again on so and so.
Thank you. Much obliged. Lordship, can it be on another date, Lordship? Because 5th time I won't be available, Lordship. Lordship. Thank you. Obliged. 15 is similar matter, Lordship. Similar matter, Lordship. 2 districts. One is from Charaido and the 15 is from Sibsagar district, Lordship.
Similar order can be passed?
Lordship.
Similar order, I think.
16.
Obliged, Lordship.
May I please, Your Lordship, my lord, here, my lord. An advertisement has been made by BTC, my lord. Your Lordship will find advertisement at page 23. And the application has been, my lord, called for appointment of graduate assistant teacher along with other graduate teacher, my lord. Advertisement, Your Lordship will find at page 23, my lord. So petitioners has found eligible. He has also applied for this.
Which post?
Graduate assistant teacher, madam, in Assamese medium, arts Assamese medium.
Where's the relevant portion?
My lord,
Relevant portion in the advertisement?
yes, my lord. Your Lordship will find in the
Yes. Where?
top, my lord, graduate graduate teacher arts. One, graduate teacher arts, their SMS medium is also there, English medium is also there, Boro medium is also there.
25, right?
23, 25. The next your lordship will find page 25 in the advertisement. Your lordship will find in the bottom, my lord, F, my lord, in case any post remain vacant after publication of the first merit list, as per the ratio of 1:1, then maximum 2 more numbers of merit list will be published. So, my lord, the petitioner has found eligible, so he has been called for interview. He has given the interview on 24/11/24, page 7, another 7, page 29. Admit card was issued to the petitioner, page 29.
Then,
Yes, written test. Then your lordship will find 25/11, so 24/11/2024. Then, my lord, select list has been published. Page 30 is the notice. Page 30 is the notice, 17/6/25, date of publication of first select list. Then your lordship will find, I will not take your lordship to the list, my lord. Your lordship will find in the relevant part of the list, page 47. Page 47. In the middle, you will also find assistant teacher arts, Assamese medium.
yes,
So, my lord, Assamese medium select list starts from 1, then last your lordship may come into the, it ends on page 59. That Assamese medium arts ends on page 59.
yes.
So, my lord, on the right hand side, the marks has been given for the candidature. 93, 93, 93, 93. Then your lordship will come 92. Candidate is SC. Assamese male SC. Then your lordship will find 92. General also they selected. General candidate. The petitioner is a, my lord, OBC candidate. So 92 is, then your lordship also find qualifying. There is 91 is also there. That is for PWD. Physically, my lord, weaker section.
You belong to what, SC?
Yes, no, OBC category, other backward class category. So, my lord, what happened? I have in the website, I have gone and I have found it. In the website, I have applied for 2 PGT also and UGT also. So now I am coming for here for the present UGT. I have found 92 marks, qualifying marks. But my lord, select list does not have my name. This is my case, man. General also 92 marks they got, or why not OBC, man? This is my case, man.
PGT and UGT.
Yeah, PGT, I am not for PGT now. Now I am for UGT, my lord. Graduate teacher. I have applied for 2. PGT also I applied. UGT also I have applied.
So we are concerned with which one now? in this case?
UGT.
Why not PGT?
No, PGT, I have not applying here now. In the writ petition, I have not come for PGT. PGT selected has not been published till now.
I see. This is only for UGT.
Only UGT, man.
So your case is that you have scored 92.
Yeah, I have scored 92.
And
even general candidate also got 92. They were selected from the list as it is evident, madam.
but then
No, 91 we have.
But then you see, there are OBCs also, 92.
No, no, OBCs also, my lord. Then also, my lord,
Now,
Yeah.
if there are only 5 posts and if there are 10 candidates having
my lord, of
92
course,
marks.
I agree, my lord, but general candidate is also there. General female 92 marks. General Assamese female 92
No,
marks.
that is not your category. Your
No, no,
category is-
I was not much category, but if my lord, I get marks, my lord, which may be taken to general also, then
No.
I may be selected for that.
See, what I want to say is that supposing 10 people get 92 marks, but the post is only 5,
Yes, my lord.
all of them cannot fit in.
No, yes, my lord, of course, I agree, my lord.
Then
I-
what would be the criteria?
So I do not know, my lord, but seniority will get, my lord. Age is there.
Please, please.
Yes, what does it say?
Criteria, in case 2 or more candidates obtain equal marks in aggregate, then the seniority of age shall be. placed.
Age shall be, then I have to know, I have, to
That's what-
let them file, my lord.
That is a general thing.
Yes, my lord. Let them file affidavit if that will show, my lord. I will
For
understand.
appointment, for seniority list also, if 2 candidates having the same grade,
Yes, yes, my lord. Yes.
the elder one will get the post.
ma'am. Yes, ma'am. Let them reply, my lord.
Belongs to OBC. Percentage, my lord. I don't think the advertise is anything.
Now, all the others category are that is
Which
eligibility, I
portion?
have that category.
Which portion did you point out, Ms. Bhuya?
Assistant teachers arts, Assamese medium.
No, which portion did you point out just now, Ms. Bhuya?
Lordship is P6.
Serial number?
Criteria. Serial number 2.
Serial number 2, okay.
2 or more candidates obtain equal marks in aggregate, then the seniority of age shall be preferred.
Okay.
And also I am from that territory also, my lord. Territorial preference is also there, my lord. Ase. It was.
Oh, that is, my lord, candidates belonging to BTR.
First, I am from BTR. I am
Heart
given
Mr.
B. Sinha, man.
B. Sinha, learned counsel for the petitioner who submits that the petitioner responded to the advertisement dated 13/2/2024 for the post of graduate teacher
Arts, man.
arts in
Assamese
Assamese medium. And according to the petitioner, he had performed well. And came to learn that he had secured 62 marks, 92 marks.
92 marks.
92 marks. Stop despite the same. When the results were notified, right notice dated 17/6/2025.
Lordship, this person's 92 marks holder, he should have made them as a public respondent on what basis they
Oh.
were selected. They have not made so. Otherwise, he will
No,
not
I-
have necessary participation.
That will come later on. Let's see. You just look into it. It'll be open for you to make that objection.
Yes,
Okay.
ma'am.
Notice dated 17/6/2025. The petitioner was surprised to see that
Side.
although general candidates and even OBC candidates securing 92 marks were placed in the select list, the petitioner who has equally scored 92 marks was left out from the list. So I grieve is before this court. In view of above issue notice returnable by 3 weeks. Miss J. Saikia, learned counsel accepts notice on behalf of respondent numbers.
1, 2, my
All.
One and two. Who are the others?
Moreland University.
Yes, but they have conducted the interview, man. I want to tell.
Petitioner to take steps for service of notice upon respondent number 3, a registered post with AD within 3 days. List again after 3 weeks. Ms. B. Boya, Learned Senior Counsel, appearing for the BTC to obtain instructions by the next day as to why the name of the petitioner does not find a place in the select list despite having scored 92 marks like other candidates. List accordingly. Yes.
Matter relates to my granting releasing my pensionary benefits to the petitioner and her 2 minor daughters. So far, the petitioner husband is concerned. He died on 21/9/2025 while he was in service, my lord. Therefore,
Compassionate family pension.
my lord,
You're asking for compassionate family pension.
my lord,
Date of death is 21/9/25.
21/9/2025.
Okay. Now, what is the procedure for that?
So far, that far is concerned, I have to file application before the authority, my lord.
Have you filed?
Well, I have approached the authority, but the authority has stated that will not be granted to me, my lord, because respondent number 10, who declared herself as the first wife of the deceased, my lord.
I see. So how to, sorry?
But so far the dispute as regards to the date of my husband is concerned, my lord, that has been reflected. So at this stage, my lord, my submission before lordship, that I am the wife, my lord. And the documents of the birth certificate of my 2 children, my lord, have been annexed, my lord.
You are married in as per the what?
Sharia Act, my lord.
Do you have any documents to show that?
My lord,
Is there any document to show that?
my lord, the social marriage was, my lord, solemnized, my lord.
But how do we accept that?
My lord, so far the marriage part is concerned, my lord. The social marriage was, my lord, solemnized, my lord. To that
See,
effect, my lord.
only problem now is that if that is a dispute, question of
There is no
fact,
dispute as regards to my marriage, my lord. So far, the dispute as regards to my status as wife, that there may be dispute, but so far the entitlement of the children, that is not, my lord, disputed by anyone else, my lord.
if it's not disputed, why you're not getting the thing pension?
Because, my lord, respondent number 10, who stated herself as the first wife, my lord. I am the second, as per her statement, I am the second wife, and she was the, my lord, first wife. Thereby, the petitioner husband had 2 wives, as per her statement, and she was the first one, and I am the second one.
Which is permissible as per Mohammedan law.
My lord, so far the Mohammedan law is concerned, my lord. 2 wives is permissible, and so for the entitlement of the retail benefits, other service benefits, my lord, it becomes, my lord, property, my lord. So the second wife cannot be, my lord, discarded, or her children cannot be discarded, my lord. They have equal right, my lord, over that property, my lord.
So what is the authority you have for that?
So far, the entitlement of the legitimacy.
Yes, entitlement of the second wife and the children.
Well, so far the children part is
On what
concerned,
basis you are saying that?
legitimate or illegitimate, whatever it may be, my lord, always treated as legitimate, my lord.
No, no. You have to give us some authority for that.
My lord.
How do you say that I should get the benefit?
Well, that judgment I have not brought, But I have not noted down one our full bench judgment of this, my lord, honorable court, my lord. Junufa Bibi, my lord, Junufa Bibi's case, my lord.
So the judgment says that one of them, the first wife, will get the pension. PPO will be issued in our name, but the parties will decide. Will
If that being the situation, my lord.
will divide the
If
share.
that being the situation, then my lord, straightway they cannot, my lord, refuse, my lord. Straightway they cannot refuse. my lord. At this stage, my lord, notice will go, my lord. If
Notice will
anything-
go and let the wife come.
Yes,
Number
my lord.
10 come.
Let her come.
We'll see. Heard Mr.
MP Shuma, my lord.
M.K. Sharma, learned counsel for the petitioner, who submits that the petitioner is the wife of
Mofizuddin Ahmed, my lord.
late Mofizuddin Ahmed, who died in harness on 21/9/2025.
My lord.
Stop. The petitioner and her late husband have how many children?
2 children. my lord.
2 children out of their wedlock. And while the petitioner was expecting to get the compassionate family pension on account of the death of her husband, the respondent number 10, claiming to be the first wife, has come in the way. And the respondent authorities are not inclined to release the pension benefit to the petitioner. From aggrieved, the petition is before this court. Next para, in view of above, issue notice of motion returnable by 3 weeks. Ms. S. Kuar, learned government advocate, accepts notice on behalf of respondent numbers 1 to 6. Ms. R. M. Barwa, SC Finance, for respondent numbers 8 and 9. And AG, Mr. Anyone for AG? No AG. Who was here in the morning? AG? A. Sharma for AG Assam. Respondent number 7. Petitioner to take steps for service of notice upon the respondent number 10 by registered post with AD due within 3 days. Extra copies be furnished to the learned counsels appearing for the respondents today within 2 days. List again after 3 weeks.
My lord, may I submit, my lord? So for the entitlement in the petition number 2 and 3 is concerned, they are children of the deceased person. So at least, my lord, 50% shall not be released to the, my lord, the respondent number 10.
No,
At
not,
least,
not that.
till reasonable date, my lord.
No,
At
no.
least 50%, because 50% they may be CMA entitled, my lord.
We
At
don't
least
know.
50%,
See,
my
at this
lord.
stage, let them come first. We'll see. No
Or
interest.
till reasonable date, at least 50% maybe, my lord, may not be released, my lord. Otherwise, one of the otherwise, further litigation will arise if the entire amount is released for recovery of that amount through civil court, my lord.
No, no.
At least 50%, or 50% may, my lord, receive the same. So far as 50% is concerned, that is subject to the outcome of this writ petition.
Issue notice on the interim prayer returnable by 3 weeks as well. The interim prayer shall be considered on the returnable date.
Obliged.
Any motion matters left? The afternoon will be having the orders.
May I please your lordship? Lordship, I beg to mention item number 32. Actually, my senior has come to court, but he is not feeling well. Therefore, pass over this matter for the day, please. M.U. Mahmood. The matter may be taken day after tomorrow. 32. Obliged, lordship. Obliged.
Now it's coming.
Item 18.
My lord, in this particular case, my lord, the respondent number 3, my lord, the director of pension was, my lord, wrongly implemented. The former director was implemented. My lord, his name is to be removed, my lord, stuck off, my lord. And my lord, the new, my lord, name is, my lord, the present director, my lord. The respondent number, opposite party number 6, my lord. His name is to be implemented, my lord. Mr. Vikas Das in place of Mr. Bhavesh Deka, my lord. He was, my lord, we are not aware of this, my lord, the change, my lord.
Instead of Bhavesh Deka, who do
Yes.
you want to implement?
Vikas Das, my lord. OP number 6. Page number 4, my lord.
Okay, but Mr. S. Datta, learned counsel for the applicant who submits that by filing this application, the applicant seeks the striking out of the name of respondent number 3, Bhavesh Deka, Director of Pension. And in his place, we implement Sri Vikas Das as respondent number,
What, my lord?
as respondent number
The respondent 3, my lord, since you'll be replacing, my lord.
3 in place of Sri Bhavesh Deka. What happened to Bhavesh Deka?
My lord, he was the earlier director, my lord. We made him wrongly a party, my lord. We have explained that, my lord, in para, my lord, 4, my lord.
He submits that Sri Bhavesh Deka was the earlier director and that the current director is Sri Vikas Das, who requests to be implemented for effective compliance of the court direction. In view of above, the application for striking out the name of Sri Vikas Deka and adding the name of Sri Vikas Das in his place is hereby allowed. I stand disposed of. And in the main contempt, in view of the order passed today, in IAC number 3720 of 2025, petitioner to file the amended cost title in 2 sets before the registry of this court.
Mine.
But after registry shall do the needful. Same should be filed within a period of 3 days
My lord.
from today.
Deeply obliged, your lordship. Deeply obliged.
For orders, item 43.
My lord, is the name of the director has been given. Yeah, only that was the necessity.
So have you taken the corrective steps?
Sir. Pardon.
Are you aware about the order passed on 28/5?
No matter the other things has been given already in previous the
Mr. Counsel,
previously.
now, Mr. Counsel, please come to page 2 of your contempt petition. Page number 2.
Ah. Contempt page number 2.
Who is the contemptor?
Yes, Malad.
Who is the contemptor?
No, this is last, this is. Momota, is the name of the director has been given, only that was required.
Name is not there.
Momota Hojai.
Where?
Today's list supplementary affidavit at page 34.
No, you cannot file a supplementary affidavit like that.
Yes, supplementary.
You are not required to file affidavit. You are required to file an application.
That name has been in the earlier also here given in the earlier petition at page dated 35/23. There has been given the name of the additional the director's own letter has proved the name.
No, please,
Please.
please listen.
Yes, my lord.
You have only implemented Director of Secondary Education.
Yes. Director
There is no name. There is no name. And this is a contempt petition.
Yes, my lord.
You have to implement the director by name.
Yes. I earlier the name was not given, director, only director, and later on, my lord, at page 20, earlier affidavit, the application that the director's own letter has proved.
Where?
Implementation we have to file implement petition. Giving director by name, party by name.
Yes.
Where is it?
Now, my lord, the earlier petition, the letter of the director herself, at page 20, my lord, earlier, at dated 28 March 23, her own letter.
Give this file to, please point out, where is that page 20?
Page
I'm not
20,
able to find
page
out.
20. Page 20. Page 20.
Mr. Counsel, you take a seat and sit down there. In the meantime, we'll take up the other matters.
20.
Call the next matter.
44.
Yes.
Yes.
But the office note shows that the service is completed. So let the matter be listed for admission, and in the meantime, directed to file affidavit.
5 and 6.
5 and 6 completed, my lord.
Laozima Court's order dated dated 14/11/2025. No, please read, the date is different. Laozima Court's order dated 6/12/2024. And the office note dated 14/11/2025 indicates that notice is complete upon respondent number 5 and 6, which has been ascertained from the tracking of the postal consignment. So accordingly, the notice is accepted to be complete on respondent number 5 and 6. Since no one appears for respondent number 5 and 6 today, let the matter be listed after 2 weeks in the admission column.
45.
Lordship, my senior legs in another court, Lordship.
Service complete. You filed your affidavit.
It is submitted at the bar that pleadings are complete. So, register to list the matter in the admission column after 2 weeks.
46.
May I please, my lord? My lord, as per last order, my lord, finance department has been made a party and service has already been completed, my lord. I think they have appeared, my lord.
Who was implemented?
Department of Finance, my lord.
Not department, this is a contempt. Jayant Nalikar, by name. You are appearing? Who? Number 2.
Yes, my lord.
You are for number 1. Have you filed affidavit? As spread for by Mr. A. Pugal, learned counsel for respondent number 1, and Miss R.M. Barua, learned counsel for respondent number 2. 2 weeks time is granted. 3 weeks time is granted to file their show cause reply. List again after 3 weeks.
I am obliged.
47 and 48.
My lord, we are directed to take step on all the respondents, and we have taken also. All were present except 5, respondent number 5. So kindly give us 2 or 3 weeks time to take step on respondent number 5.
Why do you need 2 or 3 weeks for taking steps? Is it very difficult? Respondent number 5 is headmaster, Mamora Balijan High School. You don't require 2-3 weeks for taking steps. You can take steps by tomorrow.
Yeah.
What is the difficulty? As paid for by the learned counsel for the petitioner, further 3 days time is granted for taking steps for service of notice upon respondent number 5 by registered post with ADD. List again after 3 weeks. Respondents to file their counter affidavit in the meantime.
48.
My lord, I am appearing for item number 47.
47 is what?
This is service matter.
No, case number.
706 of 2023.
That is where I passed the order.
Highly obliged, my lord.
Just give a date. On 11th.
11. Highly obliged.
49.
May it please lordship. My lord, this matter is pertaining to family pension, my lord. The petitioner before lordship is the second wife, but first wife has no objection. That is why earlier writ petition was disposed of. My lord, directing the authority to divide the pension payment, my lord, between two co-sister equally, my lord. So as per this honorable court's order, as well as the first wife is also agreed to share. So lordship may my simple prayer, make a direction, my lord, to the authority to make the payment to both the parties, my lord, equally, my lord, as per this court order.
Ms. Kaur, what is your instruction? Original PPO was sent to whom? Treasury officer. He's not returning it. Why? What is his interest? You are the director of pension. So the treasury officer works under you, isn't it? He's subordinate to you. So if you require the PPO to be returned back, why is he not returning? Who's keeping the both halves? Treasury officer. Anyone appearing? Ms. Barwa is there.
Man, the problem is that, man, the petitioner as well as the private respondent are very old ailing person, man.
Just a minute. Ms. Barwa, what do you say? Treasury officer Udal Guri. He is supposed to return the PPO both halves and they'll issue the requisites. Please write, peruse the order dated 27/10/2025. So today, Ms. S. Kaur, learned government advocate, submits that as per the instructions received by her, the director of pension had asked the treasury officer, Udal Guri, to return both halves of the PPO number E/SP/46990 to the director, to the directorate. So that the directorate can take necessary action for dividing the family pension between the two wives of late Sayyab Ali. Stop. However, the treasury officer has not returned the two halves of the PPO till date. Next para, Ms. R.M. Barwa, learned Standing Council Finance. TO is a party here. Udal Guri. Udal Guri is under BTC. Is it Udal Guri? BTC. But finance is also not a party. What is to be done then? Okay. You also for finance? Yes. So I record your name or her name?
Record my name.
Okay, instead of you, right? Mr. A. Chaliha, Lanet Standing Counsel, Finance Department, shall obtain instructions as to why the Treasury Officer Udalguri has not returned the both halves of the PPO to the Director of Pensions by the next date.
When one half of the PPO is with the pensioner, the pensioner is when the PPO, once the pension is paid, not one half of the PPO is sent to the family, and the other half is sent to the pension. So it's one half is with the pensioner, one half is with the family. I will get the necessary solution, whether the pensioner has returned the one half of the PPO and the other one in the family.
So the thing is that the Director of Pension is asking for both halves. So the Treasury Officer may ask from the
Yes.
person concerned to return back. So it's not that they're keeping both the halves with them. He may get it from the other, whoever is keeping it. A copy of the instruction received by Ms. S. Gwar be given to Mr. A. Chalia for doing the needful. Make a Xerox copy and give one copy to Mr. Chalia. List the case again. When can you get the instruction? Give a date. List the case again on 27/11. Showing the name of Mr. A. Chalia in the cost list. Okay, it may also be noted that although finance is not a party, but they have been asked to assist the court.
Lordship may kindly peruse the last order.
Now, petition of the content was the private referral of the section of it. So a hearing was called notice on 29/10/2025 at 12:30 PM in the office of the chamber of the secretary, where the petitioner of the petitioner of 5398 to appear, but the petitioner of the contact is with the petitioner 5, he didn't appear of it, and he requested for another hearing. So that hearing could not be taken because there is a dispute between the both the petitioner and the respondent 5. The petitioner of this content petition be the respondent 5 of the writ petition also.
A dispute regarding,
Regarding provincialization.
sorry, provincialization.
So, to come to the conclusion, the hearing of the voter persons is required. So he has requested time, the petition of this contact petition, with the respondent 5 of the writ. So lordship can take it out the COVID lawsuit, let him appear before the secretary. As on and the date will be informed accordingly in lawsuit. Here the yes. And direction was that the petition of the writ petition will file an appeal. And respondent 5 can be subject to the outcome of the appeal law. So for that, I think the hearing of the both of persons was required. And the petitioner, both of them call for a hearing, but the petitioner of this contact he didn't appear. He requested time.
So, when can you appear?
So that we can come to conclusion.
Please write down Mr. SMT Chisti, Learned Counsel for respondent. Learned Counsel for the respondent submits that as per the instructions received by him, hearing was scheduled to be conducted on 29/10/2025 at 12:30 PM in the office chamber of the Secretary to the Government of Assam, School Education Department. In terms of the order dated 6/9/2024, passing WPC number 5398 of 2022. So however, while the writ petitioner was present, the instant contempt petitioner, who is arrayed as respondent number 5 in the writ petition, did not attend the hearing and later on requested for another date. Considering the above submission, let the matter be listed again after 4 weeks. The respondent may conduct the hearing by fixing a date in the meantime. And Mr. SMT Chisti shall inform the court about the outcome of the hearing. Most of the petitioner shall cooperate with the hearing to be conducted.
Obvious lordship.
Time being 43.
Yes, what have you found now?
Ismail, the name of the director at page 20 in the earlier record,
What is the name?
Nam Momota Huzai, Mrs. Momota Huzai, Assistant Engineer, AES লিখিছে, Director Secondary Education, Assam, Kahilipara, Guwahati 19.
Okay, but this is only an annexure.
Yes.
What you are required to do is
But
file an.
along with that letter, the bill is already here, his salary, the petitioner's salary.
No, Mr. Counsel, please listen.
Yes, my lord.
What you are required to do is to file an application.
The
To
payment
incorporate-
of the bill,
Please write down. Where was the order dated 28/5/2025? So the petitioner has not yet filed any application to bring on record the name of the respondent. Stop as paid for further 2 weeks' time is granted to do the needful. Yes.
51.
In this matter, there is a violation of an order passed on 10/1/2025.
Similar to the idea of the hearing was made dispute between the two persons regarding conciliation.
Hearing done?
In this case also, a hearing has been on 1/12/2025.
Scheduled.
Scheduled. So
You participate.
Participate.
No, we'll participate.
Mr. SFT Chisti, Learned Counsel for the respondent submits that a hearing is scheduled to be conducted on 1/12/2025. Where?
It's member of the Director of Elementary Education.
In the office chamber of the Director of Elementary Education at
11:30 a.m.
11:30 AM. And he therefore prays that the matter be posted after that date so that he can come up with the up-to-date status. In view of above, list this matter when.
No,
Middle of December.
On 15 December.
52.
Oh, service completion, service is completed in this case, my lord. I import the petition.
I have given instruction lossip, we can take it after. After 2 weeks.
Office note 411 to 2020.
Who are the respondents?
No, four respondents, my lord. Four respondents.
Secretary, director,
Ah.
and these are two from the district.
You can appear for which respondents?
Right now, I will inform this director regarding this topic. I will try to get the instruction from the director.
So we'll list again next week. You get instructions? Where's the notice? Where's the process server report?
My lord, last month.
Sure. Sure. Write down. As per the office note dated 4/11/2025. Notice has been received by respondent numbers 1 to 4. As reported by the process server. However, no one appears for the respondents today. Further, AD card is AD card. Further, neither AD card nor unserved notice has returned back. No, you cancel that from further, okay? You'll write like this. As regards the notice served by registered post with AD, neither AD card nor unserved notice has returned back. Next para, Mr. SMT Chishti Learned Counsel submits that he will inform the authorities concerned about the pendency of this writ petition, of this contempt petition, and for that he may be given 2 weeks time. In view of above, list the matter again after 2 weeks. On so and so. 8/12.
53.
Lordship, in this, we had filed a dusty in giving this, and giving the affidavit also, Lordship. It's part of the record. Take this flag is A, your Lordship, but the respondent is not filing any bakarat to my Lordship. We'll file a customer, we'll also file an affidavit.
When?
Within a week, next week.
Mr. SMT Chishti Learned Counsel submits that he has instructions to appear on behalf of the sole respondent and may be given a week's time to file his power as well as the show cause reply. In view of above, list the matter again on so and so.
Oblige, Lordship.
54.
My please, lordship. As per last order, your lordships, I have complete the party, that is respondent number 4 and 5. Newly created, your lordships, Assam State School Education Board and Secretary Assam State Education Board. Rename, your lordships.
You want to implement them as party respondent?
Yes, Lordship.
as respondent number 4 and 5?
Yes.
Yes, any objection?
For
Will be appearing, okay. Heard, Mr.
yes, Islam.
S. Islam, learned counsel for the applicant, who submits that by filing this application, the applicant seeks implement of the controller, Assam State School Education Board, and the secretary of the same board as respondent numbers 4 and 5 in the connected writ petition. Full stop. He said, due to inadvertence, they were not implemented when the writ petition was filed, and therefore, for effective adjudication of the writ petition, the prayer made by the applicant may be allowed. Upon considering the prayer and submission made, the application for implement as prayed for is hereby allowed, highest as disposed of. In view of the order passed today in the main writ petition, in view of the order passed today in IAC number 3653 of 2025, petitioner shall file the amended post title in 2 sets within 3 days. Yes. Stop, next para. Shall we issue notice? Shall I issue notice? No, not straight away.
Admission. Earlier occasion notice was issued.
So now should I issue notice to 4 and 5? The next para, issue notice to the newly implemented respondent numbers 4 and 5. Returnable by 3 weeks. Mr. D.K. Roy. Learned, you are standing counsel?
Yes.
Standing counsel, ASSEB, accept notice on behalf of the respondent numbers 4 and 5. Petitioner to serve requisite copies of the writ petition to Mr. D.K. Roy within 1 week. This is the matter again after 3 weeks. Must readings be exchanged in the meantime.
55.
May I please allow? Lord, the writ was filed, my lord, for non-payment of pension and benefits, my lord. And in fact, my lord, thereafter, my lord, I approached the honorable court by filing an IA, my lord. And pursuant to which, my lord, the provisional pension was being paid, my lord, which your lordship will find at page 29.
29
Page 29
of the IA.
of the IA, my lord. IA 3686. Lord, I retired on 31/12/2022.
31/12,
31/12, my lord.
2000.
22, my lord. The pursuant to which, my lord, this, I approached this court, my lord, thereafter, an IA will also will find the order at page 25, starts at page 23, my lord. And in fact, page 25, your lordship comes.
This is still pending writ petition.
Yes, it is pending, my lord. Now, what has happened, my lord? I was being paid at the rate of rupees 30,000 so and so, my lord. Lordship will see and till the date of finalization of the pension by the director of pension, so and so. So, my lord, if your lordship kindly goes to the next page.
No, see,
Please.
what is the writ petition about?
Now, they have stopped my provisional pension, my lord.
What is the subject matter of the writ petition?
Non-payment of pensionary benefits.
Some proceeding was drawn against?
No, nothing, my lord.
Then
Nothing.
why?
No reason, my lord. That is why I came to this court. Now, thereafter, my lord, since the provisional pension was not being paid, I filed an IA. Pursuant to which, my lord, this order was passed, which your lordship filed is at page 29. Provisional pension was being paid, and it reflects that till the date of finalization of the pension, provisional pension would be paid. Page 29, my lord.
Page 23 is the order in the IA
Page 20, yes, my lord.
for payment of provisional pension.
Yes, my lord. And thereafter, my lord, page 29 is the order which was passed pursuant to that order, my lord.
Please read it.
Under the authority of the government of Assam Finance so and so,
And as per the Honorable Guwahati High Court's case number WPC 1255/2020 dated so and so, the provisional pension at the rate of rupees 30,185 per month, only with effect from 1/1/2023 till the date of finalization of the pension by the Department of the Director of Pension Assay is hereby sanctioned to Sri Dhruva Kumar Sharma, the then headmaster of Joint so and so, who retired on 31/12/2022. Now, Lordship, thereafter, from this October onwards, my lord, my pension has been, provision has been stopped, my lord. Then this is the ground, my lord, at which your Lordship find at page 30. There is a notification. Lordship will kindly come to clause 2.
Yes.
The payment of provisional pension shall be restricted to a maximum period of 6 months from the date of retirement, subject to approval of the competent authority. In respect of pensioners facing departmental proceeding or judicial proceedings, the existing rule shall continue to apply. So 6 months here, my lord, the second part has not been read with. There is a judicial proceeding pending before this honorable court. There is a direction by this honorable court. Only that this period of 6 months here, my lord, on the basis of which, my lord, my provisional pension has been stayed. And that too by the treasury officer.
You want to read this provision together?
Yes, because there is already an order, if you lost the page 29, till finalization of the pension papers.
No, that order is there, no doubt, but it's also subject to the certain guidelines issued by way of OM or notification.
No, but the only thing is, my lord.
See, notification is basically the interpretation of this notification.
Yes, yes, my lord. That
It
is
says
why, my
that
lord.
it has to be restricted to the maximum period of 6 months from
But,
the
my
date of
lord,
retirement.
yes, my lord.
You retire on 31/12.
No, my lord, the pension, if whereas, my lord, provisional pension was paid with effect from 1/1/2023, but the fact remains, my lord, till finalization of the pension papers, the pension, we are not at fault. It is the department which is at fault, my lord. How do I survive? And if your lordship says the second part of clause 2, in respect of pensioners facing departmental proceeding or judicial proceeding, there is a court's order, my lord.
See, we are not deciding anything.
Lordship.
I'm just telling you what as it appears. Your retirement is on 31/12/2022.
22.
Your case is that you have not been paid any pension.
True.
So ultimately, you approach this court, and this court, through the IA, said that give him the provisional pension. So they give you the provisional pension until finalization.
True.
Now then, here a notification comes.
True.
Which says that it should be restricted only for 6 months.
True, my lord.
So on that basis, you have not been given pension.
Yes, my lord.
That is why you have filed this IA
Yes,
case.
yes. In
To
fact,
this.
my
Now, your interpretation is that this has to be read conjointly,
lordship.
not separately.
Yes, my lord.
Payment of provisional pension shall be restricted to a maximum period of 6 months from the date of retirement, subject to approval of the competent authority. Stop. Now, if we understand this,
Lordship.
it means that from 31/12 to 2022, 6 months you'll be given. After then, with the permission of the competent authority, after then, thereafter nothing. Then again, it says, in respect of pensioners facing DP or judicial proceedings, the existing rules shall continue to apply.
The earlier rules.
What is that existing rules?
That, my lord, that is, my lord, by virtue of which this order was passed, the earlier order. And if your lordship sees, this earlier order was passed on 27th of May 2025. May, June, July, August, September. Now from October onwards, my lord, it has been stopped.
Yes, who's there on the other side? Who's the respondent here? Main respondent? Huh? Okay.
That is.
But instead of submitting NOC from the SMBC, we have submitted a self-signed NOC.
What is SMDC? Management.
But he was the headmaster and he has some financial liability. Without
No.
liability, he's not entitled to pension. Cannot be part liability.
So this interlocutory application has come for the first time otherwise.
Yes.
We'll issue notice. You file your response. Don't take a long time. Alright, Mr. R.D. Learned Counsel for the applicant who submits that by filing this application, the applicant prays for a direction to the respondent's authority to continue releasing of the provisional pension to the applicant in terms of the order dated 17/5/2025. Bracket annexure P4, which was passed pursuant to the order of this court dated 11/4/2025, passed in IAC number 1184 of 2025. Next, where I issue notice, returnable by 2 weeks. Mr. P.P. Datta, Learned, SC, Secondary Education. Access notice on behalf of respondent numbers 1, 2, 3.
Yes.
and 3.
Penny.
Who else? Who else are there? Ms. Escobar for respondent number 4. Finance. R.M. Barua for respondent number 8 and 9. And Miss A. Fukan. A. Sharma for respondent number 5. School, headmaster and all that. Applicant to take steps for notice for service of notice upon respondent number 6 and 7 by registered post with ASD. Extra copies within 3 days.
Only small prayer, my lord. Tendency of this, my lord, I shall not be a bar, my lord. Probably, my lord, they may even pay, my lord, because it is probably my whole conditions, my lord, that has not been read as a whole.
List again after 2 weeks. Tendency of the IAS shall not be a bar for the respondents to continue paying the provisional pension to the applicant.
Deeply.
60 of the supplementary list.
Here, an amount has been cycled that was already been paid to the petitioner notice. I have received the order, sanction order, or as well as number on the delivery of the president.
You will pay.
Abhi Guru Rahman. Token number dear deputy, Abhi Guru. Token number is from the district, which is in the last office, and amount of the notice, 2,71,693, but already on 2023 years back. Bill number 502 dated 53 and token number 2023 of 03 and positive statement.
Anyway, first thing first, which order is the not complied with? Order dated? Is it page 8?
If it 1260. 1095.
Directed to pay, take a decision on the basis of for payment of the area salary. For which period? 1st June to February 2013.
The sanction for all, I should say, where it's.
But this letter is not the latest one. This is in December 2024. Mr. Chisti,
The letter was asked for me that the bill amount that we paid. The sanction letter is the second page, okay, it was sanction on 18, it is 18 to 3. It is area salary from June to 2005 to February 2013. For a financial year, so it would continue. So the direction of from.
But the amount is different. Amount. 2,71,693 has been sanctioned. But in the court's order, what is recorded is 2,74,000.
That maybe there was a verification.
But it should have been indicated somewhere. 4,000, difference of 4,000,
I think. Yes, we see that.
not 4,000, 3,000. Difference of about 3,000 something. What have you given me? One is the communication, one is the
The last page is the.
budget
Bill number-
allotment.
Bill number, token number of the treasury.
No one is appearing for the petitioner. Bill number is what? 502,
Bill number is the 502 dated 15/3/2023.
23 or 2003? It should be 23.
23 because section was in the year 2023.
None appears for the petitioner when the matter is called. Mr. SMT Chisti Learned Counsel, by producing a communication dated 12/12/2024, wherein the budget allotment and the bill number 502 dated 15/3/2023 for an amount of 271,693. As well as the token number 2023/03/2789 is enclosed. Submits that the petitioner has already been paid the area salary due to him. And therefore, the order dated 22/2/2016 passed by this court in WPC number 1095 of 2016 stands complied with. Stop. Upon perusal of the same, this court finds that the contempt petitions can be closed. And accordingly, the same is closed. Stop. Communication dated 12/12/2024, along with the enclosures produced by Mr. SMT Chisti shall be retained in the report and marked as expert identification.
to 65.
Here we have issued this consent order. There are five. Like 6 number of cases.
What about 62? 62, item 62.
62 is the kindly see the last page of it where it is looking for a was written with the in below text of the case, Dr. Bhuvan is one of them. And last second last page of it. Second last page. Repetitioner initial was by Putul Borwa and the Dr. Bhuvan is located will find it text of the case is serial number 56.
No, no, I'm talking about Pranav Das.
One of us is the second lawsuit. First is the lawsuit, after by second, lawsuit third page. In the previous.
Okay, Pranav Das.
One of the, it is really, it is given.
Okay, what was the direction of the court?
I can't put in first case. Case 40, para 19. They begin to account the same of these code, therefore disposes the instant, is the best of it instance. The direction to the concerned authority, more particular director, second editor Assam, to consider the case of pension for commercialization of their services as research or filters by making necessary verification in terms of the section 4 of the Act of 2017 after verification of it, and without insisting upon the name being captioned on dice codes 2009 and 10 prior thereto. This access will complete with 6 months. And from the data subject to be of the director. So direction was there to verify. And as per section 4 of the 17 Act, but as directed the director not to insist upon the UDS. So we are not insisting upon the UDS. After critical verification losses, all the document losses, including the authenticated data relating the school pertaining to continuous presence of 6 years necessary as per the losses. 2017 Act, and it was found that there is a mismatch of offline and online data, and more specifically regarding the academic session of 12, 13, and 16, 17 in respect to the claim to the continuous service of the petitioner in their school. As such, this continuous 6 years present in the school is doubtful for the petitioner, as the petitioners were not continuously present in the Rupali HS school logout. To obtain the benefit of continuous under 2017 Act, it is mandatory for the incumbents must be rendered at least 6 years of continuous service as on 1/1/2017 from the date of joining, which must be 31/12/2010 or prior to that. In view of the above, the applicant comes to the conclusion that petitioner has not rendered 6 years of continuous service on 1/1/2017 from 31/12/2010. Therefore, prayer for petitioners to complete their service cannot be considered at this stage. After verification notice, director has to come to a conclusion. And not to issue some evidence, we are not issuing some evidence, we are editing the record from the school and online, whatever the complete there. So if they agree, they can challenge this not. But section 4(2) subsection 3 of the 2017 Act stipulates that the incumbent must have rendered at least 6 years of continuous service as on 1/1/2017. And that on verification to find out whether they were working for continuous 6 years or not, we found that they are not working, they are not present in the schools. Now, if they agree with this order, then it's generally they can subject their claim.
How many orders have you given me?
We have 6 petition, contact within 6 orders.
Yes, Mr. Council.
We have the difficult to gone through these orders, lordships. So let them to file the affidavit, lordship, then I will be reply. What they should do,
What remains?
lordship.
They have rejected your thing.
Lordship, they file affidavit, I will reply that, but there is a.
No, we cannot.
Lordship.
This is not a normal case, no? That you file affidavit and we decide.
As per the orders, lordship. it
Already
is-
decided by the court, saying
Lordship,
that
it is
you.
already clear the order, lordship. In order, lordship, in read petition order, lordship, it is already clear the direction, lordship, there is a clear direction, lordship. And kindly see the lordship, the 19 in page 40, lordship.
Please read. Please read.
Lordship, the code on the basis of the above analysis, the provision of the Act of the 2017, para 18, lordship, page 40. And in contempt case, lordship.
Please read.
Lordship.
Seeing will not
The
do.
opinion of the instant respondent authorities of the names of the petitioner who have been rendering service in the Venture High School and Venture High Secondary School to be captured in dice code 2009-10 is contrary to the Act 2017, as it is not mandate of the Act of 2017 to fulfill such requirement in respect of such teacher and or tutor working the Fancher High School and Fancher High Secondary School to have their names captured in the dice code up to 2009-10. Such instance is arbitrary and contrary to the provision of this Act of 2017 and accordingly interfered with, Lordship.
Yes. We are not
Lordship.
taking up India as well.
Then next para.
Lordship, taking into account the same, the court or therefore dispose of the instant bench of the writ petition with the direction to the concerned respondent authorities, more particularly the Director of Secondary Education Department Department to consider the case of the petitioner for provincialization their service as teacher and or tutor by making necessary verification in terms with section 4 of this Act of 2017 and without insisting upon their names being captured in dice code of 2009-10 or prior thereto. This exercise be captured within 6 months from the date of certified copy of judgment is served upon the Director of Secondary Education Department, Lordship. Lordship, they are working in the since 1997, Lordship. In the writ petition, we have annexed all the documents and in his feasibility report, the of the permission, all we have annexed, Lordship. After perusing the all documents, the court has passed this order, Lordship. Lordship.
Only after that.
Lordship. But and the writ petition, they have not filed any affidavit, not with their raised the objection, Lordship.
What they say here is that as per the Act of 2017, rendering of 6 years continuous service as on 1/1/2017 is required. And this has not been established, so your provincialization has been declined.
So earlier what happened was that EDAS was, department used to verify through EDAS. So they have objection that what the EDAS. Now we have verified from the schools, it's clearly stated, all the authentic data from the schools have been verified, So other, honorable court has directed to verify. So we verify from the schools and other things, all the, and found that they were not continuously working for 6 years. As on 1/1/27. Now if they agree, if they can prove they can challenge this one and then come to the alternative they will
Lordship, the school was established in 1997, Lordship. And since then, they have been working, Lordship. We have annexed the all documents in the writ petition, Lordship.
But there was no mandate
Lordship.
was only to verify.
Lordship.
Court has directed
Lordship.
to verify, Lordship. No mandate was given. That they should be provincialized.
And six years continuous service is long, Lordship, it is not true, Lordship.
Sorry?
It is
Lord.
act.
Lordship, they are servicing in the more than 20 years, they are 17 years service, Lordship. So 6 years is, Lordship, it is a very unfortunate, Lordship, it is.
The record that we there in the school lawsuits.
Anyway, you'll have to challenge this if you are agreed.
Lordship,
As of today, I don't think we can
Lordship,
proceed.
give me one day time, Lordship.
For what?
Lordship, for today, maybe adjourn lordship. My
Why?
Senior, S. Bothakur will argue lordship. Lordship, Lordship, in the read petition, Lordship, we have all annex Lordship. We annex, I will show Lordship. Lordship, sure. But there, in that, in the read petition, they have not
Mr.
not
Christie,
filed
just
any,
wait.
not filed in affidavit in opposition, not any objection, Lordship.
No, that is
Not- not-
only verification order was given, on normally when the honorable court has issued an order.
In-
verification, we normally do not object.
Rega-
But on verification, it will be considered.
Now, regarding dice code, Lordship,
And we definitely we can find.
regarding dice code, Lordship,
Because we consider, because direction to verify.
Mr. Chisti, see, I have understood what is being happening. You are again arguing so much. I'll adjourn it then. I was thinking of closing it.
Lordship, they then file the affidavit, Lordship, I will reply, Lordship, along with the old documents, Lordship. Along with the old documents, I will support, Lordship. That is the genuine case, Lordship. I believe that the genuine case, Lordship, school was established in 1997, Lordship. Thereafter, they got permission, Lordship. as
Those
per-
argument you make by filing a writ petition, fresh one.
Lordship.
Right now, rightly or wrongly, they have taken a decision. So there's no scope for opening and rehearing.
Lordship.
This was taken up, this was not taken up. We cannot go to that detail. So rightly or wrongly, they have taken a decision. They said we have complied with it. So prima facie, court feels that, okay, you have complied court's direction. They may have complied wrongly, but that will be taken care of in another proceeding, not in this manner. Okay, because we are ultimately we are concerned with the operative portion
Lordship.
of the judgment rendered earlier. The court said that you will not insist upon the name being captured in dice code. Consider them. I have the verification done and for absorption, for
Before,
provincialization. They have done it. They said that you don't have that continuous 6 years.
with regard to the
So
Lordship,
that becomes a dispute now.
Lordship, with regard to the dice code, Lordship, the earlier also the department has inquired the matter, Lordship. Lordship. I have annexed that report, Lordship. In the read petition, I have annexed, Lordship.
Heard, Mr. Your name?
DC Nath.
DC Nath. Learned counsel for the petitioner, who submits that the common judgment in order dated 12/4/2023 passed by this court, with the lead case being 1353 of 2022, has not been complied with by the respondent, and for which reason the instant contempt petition has been filed. So Mr. S.M. Chisti, learned counsel appearing for the respondent, submits that the respondent authority concerned has passed a speaking order on 18/11/2025, whereby upon finding that the petitioner had not rendered 6 years continuous service as on 1/1/2017, counting from 31/12/2010, their service cannot be provincialized. So accordingly, the speaking order was passed in compliance of the court's direction. Next para, Mr. DC Nath, on the other hand, submits that this court had indeed taken into consideration all aspects of the matter and thereafter passed the judgment and order dated 12/4/2023. And therefore, it will not be open for the respondent to not grant the benefit of provincialization to the petitioners. Stop upon perusing the judgment and order dated 12/4/2023 and also the speaking order produced by Mr. SMP Chisti. This court finds that prima facie the respondent has complied with the court's direction by passing the speaking order. Although the same has deprived the petitioner from being provincialized. Therefore, this court is inclined to close the contempt petition. Stop, notwithstanding the closure of the contempt petition, the petitioner would be at liberty to challenge the speaking order by way of appropriate proceeding as may be permissible in law. Please so advise. Stop, the speaking order produced by Mr. Chisti shall be kept on record and marked as X for identification. This order will go in all the cases. 60, 61, 62,
Up to 66.
63, 64, 65, 66. Separate orders, okay?
With liberty to lordship to file the challenge this.
Mr. Nath, even without liberty, you can challenge. There is no bar.
But lordship.
But I've indicated.
Lordship.
I have indicated otherwise. Sixty-six also is included. How many orders have you given me?
6 cases. Yeah, six.
No, there are 7. 6 or 7.
How many
6, okay, 6, okay.
All of 6 cases.
My lord. The method is here, everything.
Can you explain to him?
What was trying to explain, we didn't understand completely.
Then materials is here also.
আপনি ইয়াতে প্ৰেজেন্ট ডাইৰেক্টৰক এখন চিঠি দিব লাগিব ই হাইকোৰ্টৰ কেছটো যে পেণ্ডিং হৈছে অৰ্ডাৰটো দিব লাগিব ই এখন ইনক্লুডিং পেটিশ্যন ফাইল কৰিব লাগিব এনেকে নহ'ব নহয় ইয়াতেতো আছিলেও নহ'ব এইটো প্ৰচিডিউৰত যাব লাগিব
প্ৰচিডিউৰটো হৈ আছে
ইনক্লুডিং পেটিশ্যন আইএ ফাইল কৰিব লাগিব ইনক্লুডিং পেটিশ্যন দিব লাগিব দি নামটো ভৰাব লাগিব
You have to file one application
Yes.
by saying that I want to implead so and so, Miss so and so of this thing position as the respondent number so and so. Then we'll allow, then you can go ahead. You are only referring to some document in the contempt petition. So by the document in the contempt petition, we cannot array that person.
The High Court order is there also, sir. The High Court's direction order is here.
No, you file one application.
Yes, in the file.
Please, no, in the file, it may be there, but you have to file one application
Yes.
to implead that person by name.
Then by
Then-
name means the director,
By name.
director name already here, my lord, already. Already here, they are given, director's name. Ajit serial আছে না? Today's petition, here is Momota Hosai, the name is here in the director's name.
What is your case number?
Today's petition.
43, item 43.
Yes, 43.
Can you see do you have the cost list with you?
My lord,
Do you have the cost list?
policy, yes.
See item number 43.
43.
So-
Item 43.
Please read the party.
Party is, petitioner is here, Sukanta Sarkar and director,
Versus
director. Oh, yeah.
director.
Director.
So director is not by name.
No, my lord, the name has been given, Momota Hosai.
Where? In the cost list?
Today's petition, today's affidavit, today's affidavit. Here is name, MS Momota Hosai. AES, Director of Secondary Education, Assam, Kahilipara 19.
Where? Where is that?
My lord,
Where is that name?
name here in the today's affidavit. Here is name already, Momota Hosai.
Show me.
Today's affidavit. Momota Hosai. Only for the name, the today's affidavit has been given. Only for the name. Earlier, it was given as director, but today it is as directed by the High Court. Now name has been given. Bill is also there.
This is additional affidavit. You
Only
cannot,
for her name, only for her name.
no, even if it's only for her name,
Yes.
you have to file application, not additional affidavit. You have to file one IA. You have to file one IA, interlocutory application, seeking permission of the court to implead Momota Hosai
Yes.
by name. Not additional affidavit. You have to file IA. Then if IA is allowed, then you can incorporate. Okay?
Name, a date has been given. A date may be given, my lord.
Yes, we have given you
Okay.
2 weeks time.
For admission item 23.
Photo state করে দিয়ে দিবি, photo state করে দিয়ে দিলে হবে।
Yes, what is this?
Please, your lordship. Lordship, the matter here pertains to provincialization of the services of the petitioner lordship as grade 4 staff. Lordship, pleadings are complete here, lordship. Lordship may fix another date for taking up the matter for admission, lord.
It is submitted at the bar that the pleadings are complete and therefore the matter may be listed for admission hearing on a convenient date.
On it.
Don't worry about your appearance. List again on so and so. Give her.
Any
When?
date after 2 weeks, lordship.
You want a date?
Lordship.
Is there any urgency?
Lordship, 22 matter, lordship. Any date, any convenient date up to your lordship's lord.
Let's see any date. we give. 11, 12.
Much-
11, 12. Correct. It's not recently. Recently is happening since last month. Again, they've changed. Who's the new council? That was AK Bhuya is the new council. This submission was going on since last month. So what is the problem then? Hmm? So what is your instruction then? Huh? You are for the BTC. So that is why, where is your instruction? None appears for the petitioner when the matter is called. Stop. The BTC respondent has also not filed any counter affidavit. Despite last chance being granted, white order dated 14/7/2025. Stop. Today, Mr. Huh? A. Sharma, learned counsel submits that the BTC respondents have recently engaged a new standing counsel, that is Mr. A.K. Bhuya. And himself to represent the BTC. Stop. He therefore submits that he may be given some time to get the instructions and to file counter affidavit. Next para, considering the above submission, this court reluctantly grants further 3 weeks time for filing counter affidavit. Failing which, court shall impose cost on the BTC respondents. Next time you come, I'll give you some cost. Yes.
In this case, my matter relates to non-payment of area salary relating to subsistence allowance of 25%. After my reinstatement, they have not filed affidavit. Madam.
Subsistence allowance, suspension.
Yes,
Who are the respondents?
Education Department, Madam. Director of Elementary.
Elementary education.
Yes.
Now, wait, what is the order you challenge?
There is no such challenge, my lord. I am paying for area salary. After my reinstatement, 25% of balance subsistence allowance I am entitled to. And the authority also submitted the proposal that has not been finalized. So present status is, my lord, they will apply. Elementary.
There is nobody else left for elementary.
What? I'm lost.
Oh, Miss Ascor. Ascor, government advocate.
Elementary.
She's for elementary.
Next week, my lord.
I think she was here. Where she's gone?
Time lo 27.
Ascor.
Oh, yes,
We'll have it next week.
yes, but next week, any day.
Miss Ascor, learned standing counsel, elementary education, is said to have, is said to have, is said to be feeling not, is not feeling well. No, you write like this.
It is elementary.
Yeah, you write like this. It is reported, cancel the order. It is reported that Ms. Ascor, learned standing counsel, elementary education, is not feeling well. And therefore, on a premier on her behalf, let the matter be listed again on so and so.
In this case also, my lord, department has not filed affidavit, my lord.
Elementary.
Yes, my lord.
This is item number
28.
28. You are not there in 27. Just now we,
মানে as for পইচা তুমি কৰিব পাৰিলা হয় তাত।
but what is your instruction? What is your instruction?
Item
27. You say you can appear, then what is your
Yes.
instruction? Petition is claiming for subsistence allowance area.
area. 75% we have received, I have received, balance 25%.
Okay, anyway, you make a submission on next court date. Now, as regarding this case, what is to be done? How much time?
A short date may be given, my lord, last 2-3 occasion. my lord.
Okay. Ms. P.K. Bora, Lanet, Standing Council, Elementary Education, praise for and is granted further 2 weeks' time, working instructions.
6 on our
List again, so and so.
lies.
29.
Malad, kindly peruse the last order. As per the last order, the respondent is supposed to file the counter manner. But till that they have not filed. Malad, a short that may be given with the legal aid matter, Malad.
You are good, Nick?
Or something. Or something.
Are?
Or something.
Are sang, just given writing. Learned counsel appearing on behalf of Mr. Dinath submits that affidavit of the respondent number 5 is under preparation and the same will be filed within the next 2 days. In view of above, let the matter be listed again after a week
But the date may be fixed, Malad.
on so and so.
212, much above.
Then after a week, you don't say listed again on 212, huh? Without mentioning the week.
30.
File relating to the department, first lordship, which place lordship. Where of the lordship, acquired was lost lordship, a report committee, a copy was constituted for continuing report. Thereafter, the original letter was not found lordship, the hard support. So lordship is brought in FIR, but subsequently lordship became the filing. Otherwise, we keep an impact, their participate in filing just now, an hour. So I know sometimes go through that filing, it is explaining. So that will give the easy.
The original records, what do you call the hard copy has been misplaced and but you have the e-file. So what do you want to, you want to file a counter affidavit?
The respondents in the higher education department have filed a short affidavit to the extent, my lord, to stating that they have misplaced the file. And some committee has been constituted, only to that limited extent that affidavit has been filed. Now, my lord, that the e-file has been retrieved, my lord, lordship can fix this matter, my lord.
Okay, Mr. D. Upamanya, Learned Standing Council,
I am out of pension, my lord, I am not receiving regular pension. my
Higher Education submits that although the hard copy of the records have been misplaced, but he has been furnished with the e-file. And therefore, in praise that he may be given some time to file a detailed affidavit. So Mr. R. Bo Pujari, Learned Counsel for the petitioner, submits that there is some urgency in the matter since the petitioner is without
Without pension,
pension till
my
date.
lord.
When did you retire?
My lord, during his service, during the, my lord, continuance of DP, my lord, he retired. He superannuated.
When?
My lord, in the year 2019.
Without pension, although
Yes,
although he has retired in the year 2019. review of above, list the matter again on so and so. When? 2 weeks, 3 weeks? When?
Can it be on 11, 12?
11, 12? 11, 12, 2025.
I'm so obliged.
May it please your lordship. Sir, my lord, pleading, sir, complete my lord. Your lordship may be dispose of the matter, my lord.
Dismiss the
Petitioner
matter.
before lordship, my lord, challenge the
Dispose
my,
the matter or dismiss the matter?
my lord, as your lordship. My lord, impugn order, my lord, annexer 18, page 64, my lord. Pardon, Koilo. My lord,
What is that?
my part may be hurt and his part may be
This
completed
is
next day.
regarding pay scale.
My lord, wrongly interpreted that my scale of pay was given in 2018 in spite of my scale of pay was given graduate scale of pay in the year of 2012. That is challenge for lordship.
Anyway, see, you were given time to file reply affidavit.
I already filed reply.
Okay. So we'll list it for admission hearing.
My lord, can it be taken up on Monday at the top of the admission list, my lord?
I don't know.
Because
The
of-
Monday not be possible. What is the urgency?
Urgency is meant that he is suffering, my lord. He has the not allowed to, my lord, is the headmaster, my lord, from 2023, my lord. And junior are, my lord, the headmaster, so the matter is urgency.
It is submitted at the bar that the pleadings are complete and the matter may be taken up for admission hearing at a convenient date. In view of above, let the matter well listed on 212 for admission hearing.
212.
Be ready for that. 212.
212. Mark. Can it be on 3rd, my lord? 3/12, my lord.
This Wednesday, we'll have the hearing date.
I'm required my Thursday or Tuesday, well, otherwise not.
Huh?
Well, Thursday or hearing day, I want to on third.
You are looking at a calendar which is 2024, I think.
No, 9/12, no?
Oh, 26 calendar. You are looking at 26 calendar.
Acha, I'm sorry for that.
We are giving you Tuesday only.
On 2/12, my lord.
212 is Tuesday only.
2/12, mark. I'm
I am appealing for respondent number 2, and Assam State School Education Board. We have obtained Petabytes comment
In item number?
33.
Okay. Mr. D.K. Roy, praise for and is granted 2 weeks time to file counter affidavit
Lordship, a date may be fixed.
on behalf of the respondent number. Not on behalf. What did I say? Of respondent number 2. Mr. S.K. Mehdi, learned counsel, appears for respondent number 4. And what do you submit? And submits that the AG Assam has no role. List again on so and so. Any date.
34.
Your lordship may kindly see the last order, my lord. That may be there, my lord, but without any inquiry, they have taken action against me. My lord, notice has been issued after filing of this case and very recently, my lord. I have noted down the dates, my lord.
Madam,
This-
just a minute. Let me
Yes,
ask him some questions
Yes,
also. See, you are supposed to get instructions that how the proceeding was conducted. You say that he is not participating. He or she? He.
He, my lord.
He is not participating. Do you have the DP records with him? No, you see, if a person does not participate, you can go ex parte. make a record of finding that person is not willing to participate. So we'll have to proceed ex parte and proceed. What have you done?
That's the issue. On 8, 9, because the private certificate is invalid.
Have you filed an affidavit?
Your lordship, the case is very much clear. Your lordship may kindly see, we have filed this petition on 24/10/2024. Here notice was issued on 14/11/24, and after receiving notice, my lord, issued show cause notice to the petitioner that is dated 2/3/2025, this year, my lord. Then one notice is dated 2/9/2025, then 7/9/2000, then 18/3/2025. Very recently, after receiving notice in this case, my lord, prior to issuance of this impugned order, my lord, no inquiry was held, my lord. This impugned order is dated, my lord, 19/8/2024. And now they are saying he has not participated. Now they have issued notice, my lord. Now the matter is under consideration of this honorable court. And every day they are making the same submission, and in this way they are dragging the matter, my lord. Here my prayer is that, my lord, there is a gross violation of Rule 9, my lord, of the Assam Service Discipline and Appeal Rules, my lord. So on the ground of violation of statutory provision of law, my lord, your lordship may be pleased to set aside this order and give a direction to them to hold a fresh inquiry by following the procedure. And Rule 9 says, my lord, without prejudice to the provisions of Public Service Enquiry Act 1950, no order imposing on a government servant any of the penalties specified in Rule 7 shall be passed, except after an enquiry held as far as may be in the manner hereinafter provided. Then the manner is given below, my lord. The disciplinary authority shall frame charges, definite charges on the basis of allegations on which enquiry is proposed to be held. Then, my lord, the government servant shall, for purpose of preparing his defense, be permitted to inspect and take extracts from such official records as he may specify. So these procedures it should have been followed, but nothing was done, my lord. Only on the basis of a report of the DEO, this impugned order was passed. They have taken action against the petitioner that he has misappropriated.
Sorry?
They just file over.
When will you file?
Weeks.
We'll fix a date. You file it, otherwise we'll consider it as it is. Mr. P.K. Bora, Learned Standing Counsel, Elementary Education. Department prays for further 2 weeks time to file counter affidavit on the basis of the instructions he has received. List the matter on 9/12. On which date an attempt shall be made to dispose of the writ petition.
Obliging.
35.
May I please, your lordship? By instruction.
As far as the last rotation, your lordship instruction has been showered, your lordship. In part that your lordship instruction is in.
What instruction?
It's okay, fresh episode.
My lord, such type of instruction, lordship, has been coming for last 1 year, almost, lordship. They are just only saying that the
No.
matter will be placed before the cabinet.
Anyway, just tell me what is the matter about?
Two affidavit, lordship, they have filed. In both the affidavit, lordship, they have stated the same thing, that the matter will be placed before the.
Before that, what is the matter about?
My lord, the matter is non-payment of a gratuity and final pension.
He
My lord,
retired.
Retired,
Gratuity and
retired in
discharge.
the year lordship 2019 in the month of September. Thereafter lordship, this other benefit has been given, only gratuity and final pension that has not been given on the ground that certain period, that is more than 5 years period, he was under deputation. That period was not regularized.
Gratuity and final pension.
Yes.
What are you given? Provisional pension?
Provisional he
Till
is
now.
given. But the amount lordship, there's a major head lordship, that is your lordship is ever in the respect of gratuity, that has not been released. Only on that ground, lordship, they are taking time, and even after filing this case lordship, almost for last 1 year, they are taking time on the ground that they are placing it before the cabinet.
Okay.
But
So-
till date, they have not placed.
Okay, so what have you done to earn such ill luck?
My lord.
What have you done to earn such ill luck?
My lord, it is their part lordship, they have to.
No, what are you? You are working as what?
Working as lordship, last lordship, I retired from service as a district elementary education officer.
Before that?
Before that lordship, yes.
You were on deputation.
Lordship?
You were on deputation.
No, certain period lordship. Certain period, he appointed in the year 1998 in a duly regular selection process. And from lordship 2003 to 2009, this period lordship, he was under deputation. That was under SSA. He got the salary.
2003 to 2009.
2003 to 2000. In fact, lordship,
Is
he
it
was.
because of that? Is it because of that?
Yes, because of that period.
So how the period has to be treated? That is the question.
He was on DT, he received salary, but the initial deputation was for 1 year. After completion of 1 year, he was not released. He was allowed to continue work. Proposal was submitted by the authority.
How many years?
It will be more than 5 years. Deputation period was more than 5 years.
Deputation is normally for 3 years.
Initially, it was for 1 year. 2003, when he was posted for under deputation,
You can be on deputation for a maximum period of how many years?
Lordship, as per their OM lordship, if it is for 5 years, the department can regularize that period. If it is more than 5 years, it will be placed before the cabinet. That is the stand they are taking.
So this is 6 years now.
Yes, almost 6 years.
More than 5 years?
More than 5 years.
That is why it has to be put before the cabinet.
Yes. That is the stand they are taking for last 1 year. Two affidavit lordship, one is filed on 11/6, that stand was taken, and subsequent additional affidavit lordship was filed on 15/10, same stand was taken. Now till date, the matter has not been placed before the cabinet. Today instruction is also saying that it will be placed before the cabinet. This is the stand.
This kind of issues are to be placed before the cabinet.
That is their stand.
Under what provision? There must be some rules for that.
My lord, they have annexed one office memorandum in their additional affidavit.
Yes, where is that?
That is if your lordship kindly come to paragraph 4 of their affidavit in page 48.
Page 14.
Page 48.
48.
Lordship. Their additional affidavit, para 4.
Okay, this is the thing.
And para 8, your lordship may kindly come. 4 and 8. and para 8, Lordship.
No, come to page 51 straight away.
51.
This is the OM.
This is the OM.
So which part of the OM is the relevant one?
I have not got that provision that it will be placed before the assembly. I think. বুঝি পাইছো whatever may be placed তো কৰিব লাগিব ন
Because now the matter shall be placed before the honorable cabinet the lordship.
Where is the provision which says that matter has to be placed before the cabinet?
that is not in the OM lordship perhaps but they are in their affidavit they are saying. My submission is that lordship, if they want to place it before the cabinet, that should be placed, but that they are not placing, they are taking that stand.
See,
There's no problem on that.
regarding this gratuity, DCRG, can you deprive the person from gratuity?
Honorable cabinet your lordship, that the direction of good direction is your lordship and actually it is your lordship. By compliance of the.
Your lordship may dispose of this on that line, that matter may be placed and the entire exercise may be carried out within the particular, that can be lordship. In that even lordship, I think it will be easy for them to place it. Yes, direction to lagay.
Outcome is.
Kora, mura apatti nahi, to move place kora apatti nahi, kora.
So shall we dispose it off then? Heard Mr. M. Khan, learned counsel for the petitioner, and Miss P. Das, learned SC, secondary education. Mr.
It's also.
R. Boro, for respond number. For respond number 5. Don't worry about that. Yes.
Lordship, we have filed, I have been for 7 and 8. Number 7 and 8. We have filed our affidavit and in the affidavit page 44, we have stated specifically the queries by the honorable court regarding the OM. And the OM, as per OM, lordship, if the period is more than 5 years, then it has to be paid before the case.
Okay, we were discussing that only. What were you doing? Sitting there idle.
I say. That is.
We were discussing that only. Nobody said that you don't have to give it to the cabinet. Our things that is not happening. Nobody is trying to place it before the cabinet. So court will direct, go and place it before the cabinet. Whatever decision they take, it's up to them. Your good name? Miss N. Chaudhary appears for the respondent number 7 and 8. Anybody else? I have already recorded your name. And Fugan for respondent number. Then Fugan for respondent number 4. RM Barwa for respondent number 8. Just see, are they all there? Next para. Having regard to the nature of grievance projected by the petitioner, the writ petition is taken up for disposal at this stage. To stop, the petitioner retired as the District Elementary Education Officer, Kokrajhar, on 30/9/2019. And as he has not been paid his DCRG along with the final pension, he has initiated the instant writ petition. Stop. Notice of motion was issued on 2011-2024. Whereafter the respondents have appeared and who has filed affidavit?
Lordship, respondent number 1. Both
And-
the affidavit filed by respondent.
And only the respondent number 1. Who is respondent number 1? Secretary to the Government of Assam Education Department has filed the affidavit of deposition.
এটাই ভালো হবে, তোমারও ইজি হবে।
Stop. In the affidavit of position at paragraph number 4, the observation of the Finance Department has been abstracted, which is to the effect that since the period of deputation of the petitioner, where were you deputed? Where?
But it should be from
No, no,
1/4/2000.
Where? Where were you on deputation?
My lord,
Where did you go on deputation?
deputation under SSA. He was
The deputation period of the petitioner under the Sarva Shiksha Abhiyan was more than 5 years,
yes.
with effect from 25/11/2023 to 22.
My lord, there are two states, lordship. One is 1/4/2001 to 24/11/2003 and 25/11/2004 to 22/9/2009.
No, that's okay. I'm talking about the Finance Department's observation. 22/9/2009. And therefore, the matter has to be placed before the cabinet. To stop further, it was observed that since the extension period of deputation for 7 years was issued only on 27/12/2016, after the petitioner was repatriated,
That is the date of ON.
the period of 7 years as on deputation admissible not admissible, period of deputation for 7 years subsequently allowed will not apply to the case of the petitioner. Stop. On several occasions, this court had directed the learned counsels appearing for the respondents to obtain instructions as to what is the up-to-date status of referring the matter to the cabinet. But till date, the status of the case is that the matter will be placed before the cabinet. Stop. In this connection, Ms. P. Das Lanet, Standing Counsel, Secondary Education Department, has produced a communication dated 18/11/2025 made by the Secretary to the Government of Assam, School Education Department, to the Senior Standing Council of the State Department. Stop. The learned counsel for the petitioner, on the other hand, submits that the petitioner, despite having retired from service on 30/9/2019, has been deprived of his retirement benefits for none of his fault, and is only given provisional pension as on today. And therefore, he prays that the respondent authorities may be directed to speed up the matter so that the petitioner can receive his entitlement. Next, para, upon considering the submissions made by the learned counsels for the parties and upon perusal of the materials available on the board, and without expressing anything on the merit, the writ petition is disposed of by directing the, who is to be directed? The respondents, more particularly respondent number 1, is directed to place the matter, place the case of the petitioner before the, how is it to be placed? Who will decide what matters are to be placed before the cabinet?
Not cabinet is sitting frequently. My friend can.
No. How are the cabinet memorandas prepared? Cabinet secretary is the chief secretary, isn't it? Cabinet secretary is the chief secretary. So he will organize the agendas. Will place the matter before the competent authority for onward placing the matter before the cabinet sitting.
One your lordship reference has been made your lordship by your lordship.
Same thing. Secretary, subsecretary.
Yes, your lordship. So your lordship and your lordship in my affidavit. Your lordship, direction can be given your lordship.
That is what I'm giving now. What else do you want?
Lordship, it will be placed through, I think, lordship, chief secretary, as your lordship is that. Party will.
No, I've already said the competent authority. Please read the last line, sentence.
That's number 1 puribo.
Without further delay. I said dispose already, na? The communication dated 18/11/2025, produced by Ms. P. Das Lanet, SC, Secondary Education, shall be kept on record and marked as X.
And let some direction may be given after placing it, your lordship, the admissible amount, lordship. Otherwise, lordship, again, he has to come, lordship. If your lordship is not. giving
No,
that-
we'll limit to the direction to that only. They will do it.
Lordship,
Okay.
time period.
We cannot
time
say
period.
beyond that.
Lordship, time period is.
No. They will place it immediately.
But I think, lordship, if you, if that is the lordship, matter should be kept in pending, lordship, in that circumstances.
No. No. I've disposed it of.
Lordship, otherwise, lordship, if time bound is not given.
Mr. Your prayer has to be reasonable, okay? And court has considered and passed the order as deemed fit and proper. Don't go beyond that.
Well, your lordship will see that this petitioner lordship is waiting for last 6 years. If you for this amount lordship, and if you.
Don't make me say more things, Mr. Counsel. Otherwise, I'll add some more thing.
My lord, I'm praying only for a time bound lordship.
No, that I'm not
Your
giving any
lordship
time
will
bound.
do it 5 years, 5 months.
No, no, I'm not giving any time bound. See, they'll handle it with the responsibility. That's all. It's a direction from the court.
Otherwise, lordship, my prayer lordship,
He's right. The Mr. What's his name? M. Khan, learned counsel for the petitioner, prays for a time frame for placing the matter before the cabinet. But however, this court would not like to fix any time frame. Stop. It is however made clear that the respondent authorities shall take necessary steps as directed here and above without delay. Okay, next.
46.
May I please, your lordship?
Yes.
This matter pertains to, my lord, non-releasing of final pension, gratuity and leave encashment to the petitioner who retired on 31st of August 2024. My lord, due to the intended negligence and delay on the part of the officer, that is the principal of the school, the pension papers are still under objection before the director of pension, my lord. This is the 4th time, my lord, those papers are under objection and for correction, my lord. Like final
Who's respondent number 6? Then
Final pension to this party as a whole, whereas
how much time do you require?
3 weeks time.
Please write with the appearance of Mr. M. Khan, learned counsel, who represents respondent number 6. Notice is complete upon respondent number 6. As paid for by the learned counsel for the respondents, further 3 weeks time is granted for filing counter affidavit. List again on so and so.
May I submit one thing, my lord? This notification has been passed on 6/9/2025.
Yes.
Lords, can you
About
go
what?
to this? Regarding, my lord, the payment of provisional pension shall be restricted to a maximum period of 6 months from the date of retirement.
Yes.
So, my lord,
is a
petitioner is
instruction.
apprehending this notification will affect in getting his pension, my lord. Provisional pension, my lord.
You have not got your provisional pension till
Provisional
now.
pension I am receiving, my lord.
Since
But
when?
as per this notification, the payment of provisional pension shall be restricted to a maximum period of 6 months from the date of retirement.
That we have come across in some other case also.
Yes, my lord.
For how long you have received?
From December, my lord. That was also, my lord, released after delay of 3 months, my lord. From December, he is receiving.
What?
10th, my lord, can it be 10?
We can have it before that. Don't keep it on the last date. Any date?
Yes, fine.
Okay, next case.
7. Applies.
Made this. In this case also, my lord, some recovery has been made from a retired employee, my lord. He was a teacher, my lord. He retired from service. After his retirement, my lord, some recovery was made. On 31/10/2023, He retired from service, my lord.
This matter pertains to, please write, recovery made from the petitioner. You on account of wrong fixation of pay. Who has filed affidavit? Anyone?
The finance department has filed.
Although the finance department has filed counter affidavit, but the secondary, is it? Secondary education department is yet to file the same. As a last chance, 3 weeks' time is granted. List again on so and so.
Oblige. 1612.
Your lordship. Potential compassionate appointment, your lordship.
Compassionate appointment.
Yes, your lordship. The other side may file in affidavit, your lordship.
Compassionate appointment has been stopped already. What are you applying?
Lordship, what happened is
Now
that
it's
in this case.
compassionate
lordship-
family pension.
No, lordship. Here in this case, your lordship, on 11/9/95, your lordship, for the first time I did file the representation, your lordship. So that point of time, and lastly on your lordship pays lordship pays 31 may kindly be looked into, lordship. Minutes.
Died in harness.
Yes,
Was-
your lordship. Died.
that was in-
yes, your lordship. That's the
Please
reason.
listen.
Remark.
Please.
Lordship, remark.
Died in harness, how many, when? 30 years back.
Yes, your lordship.
And today you're coming as if it's a fresh
No,
case.
today I don't come, your lordship. What happens that the subsequent, your lordship, I have filed another representation on 38/08/2023.
You file one more representation there.
Yes, your lord, before the district
Go and file
commission.
one more.
Yes, your lordship. So may I read you, lordship, the minutes, page 31, your lordship.
Not required. We'll give you some time. How much time? He does. 3 weeks' time granted to
A date may kindly be fixed, your lordship.
respondents for filing counter affidavit.
A date may kindly be given.
Yes, list again on so and so. Next year.
7 to 10. 7 to 26.
Actually, what I have got instruction is that the college authority, saying the proposal is correct form, madam. Now the department is communicating with the college authority. Regarding, madam, the salary of 4 months.
Yes. You have not received instruction. Why? I've made an observation here.
Yes.
By next date, will matter can be disposed of.
But no, I have not received detailed instruction. They have verbally started to come.
What?
The college authority, the principal, college authority has not given the proposal in a proper format for those months. That's why. it was rejected.
So you give now.
Now, my lord, department is communicated with the college authority. and
These are that is it not that a technical problem? Not proper format and all that. You do that. If person has worked for 4 months, you give them money.
Otherwise,
That's what. If they are entitled, give them.
can fix that, updated instruction or.
Please write down. Mr. P. Das, Learned Counsel. I'm sorry, Mr. S. Das, Learned Standing Counsel. Standing Counsel.
Higher
Higher Education submits that as per the verbal instruction received by him. The what did you say?
college authority
The college authority did not submit the proposal in the proper format, and for which reason the 4 months' salary has not been prepared. Stop considering the submission made. Mr. S. Das shall obtain appropriate instructions by the next date.
Lordship, I pray for fixing a date, Lordship.
Uh, so that the matter can be final disposed of. List again on so and so.
Lordship, if possible on 10th of December, Lordship.
No, I'm asking Mr. Das. When can you? 10th. Give a date after 2 weeks.
10th December, huh? 10, 12th. Highly obliged, Lordship.
May I please, Lordship?
This is the last.
We have received the affidavit on opposition on 17/11/25, my lord. Lordship, we need to some time to reply.
How much time?
4 weeks. And item number 15, 8 and 59, my lord. They have not filed affidavit, my lord.
First case we have filed an affidavit.
Will cover. That will cover.
Cover, my lord, that regarding the two petitioners who have tried for us, we'll get those two also here. While there will be other two cases also.
You'll
First
file.
one we have filed. The first one we have filed, the other two cases we filed, and they'll give a reply on the first case.
Oh, that's okay. Reply, you don't have to worry about it. Thing is that what I'm asking you is that affidavit filed in the first case, will it cover the other 2 cases, or you want to file a separate one? Okay. Mr. F. Ugan, Learned Counsel for the Elementary Education Department, submits that counter affidavit has been filed in WPC number 5 of 2023. And that he needs some more time to file the counter affidavit in respect of WPC number 8379 of 2022 and WPC 121 of 2023. Your good name?
A. Hussain, behalf of J. Borbuya.
Mr. A. Hussain, Learned Counsel, appearing on behalf of Mr. J. Borbuya, the lead counsel for the petitioners, submits that he may also be given some time to file rejoinder affidavit to the affidavit opposition filed by the Elementary Education Department in WPC number 5 of 2023. Stop next para, considering the above submission. 3 weeks? Let the matter be listed again after 3 weeks. Parties are at liberty to exchange their respective pleadings in the meantime.
Fifty-seven, 58, 59.